My please, Lordship. PCR may be required, Lordship.
This year.
Lordship. However, as per direction of this honorable
Certificate
court,
case.
Lordship.
Certificate case.
Yes, Lordship. However, Lordship, as per direction of this honorable court, through an additional affidavit, I have submitted the deposition of 3 PWs. It was reflected on last order, 13-3. Order dated 13-3, Lordship.
Where it is pending?
It is additional district judge Rangia,
Okay. Heard, Mr.
PK Sahuria.
Learned counsel for the accused and Mr. Portakur, learned additional PT for the state respondent. The learned counsel for the accused submits that person to order dated 13-3-2026, he has filed an additional affidavit bringing on record the evidence of 3 witnesses examined by the learned trial court. He further submits that to dispose of this petition, the trial court record will be required, and as such, he has consented to call for the record of the learned trial court. Where allowed, it is provided that registry shall call for the scanned copy of the record from the learned trial court, fixing the matter on when?
Lordship, 7 of August.
7th of August. Okay.
Deeply obliged.
Regular bail application arising out of office of PS case number 274/26 under section 1172-109 P within bracket 5 of BNSA. Annexure page number 10, that is the FIR dated 18/6/2026. Page number 10. This is a dispute arises.
Since so when you were behind the bar?
Lordship, last 11 days we are
11
behind
days.
the bar. So we'll endart our services being a security personnel.
Where is the FIR?
Yes, FIR Annexure page number 10. FIR dated 18 July 2026.
Portakur?
The clause, one another clause FIR has been lost by the ESIC director. That is Annexure D page number 20. Can you be page to page number 20? The ESIC director clearly mentioned that when the security personnel has rendered their services to protect the
No, now tell me on the basis of which FIR the case was registered.
on basis of the first FIR, FIR dated
FIR.
18 July 2026, Annexure page number 10, Annexure A.
Okay.
Arising out of the office of case number
So
270.
you were behind the bar for last 11 days.
12 days, your lord.
12 days.
11 days. 11 days.
Mr. Portakur? Further custodial detention may not be required.
May not be required to your lordship in this.
Third, Mr.
I'm sorry.
M. Soikia, learned counsel for the accused. Then also heard Mr. P. Portakur, learned additional people for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused Himangsu Sinha and Puran Bahadur, who are languishing in jail hazard in connection with Posisto PS case number 274 of 2026 under section 117 within bracket 2 stroke 109 stroke 117 within bracket 2 stroke 3 within bracket 5 of BNS 2023. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Bhobesh Kolita on 18th of July 2026. The allegation against the present accused persons is that on 18th of July 2026, they have assaulted the informant and kept him confined inside the premises of ESI hospital.
Yes, sir.
ESIC
Yes, sir.
hospital. Where it is? Peltola.
Yes, sir.
Peltola. And when his brother-in-law Bhaskar Koleta came to rescue him, they have assaulted him also. Mr. Soikia, learned counsel for the accused, submits that the accused they are the security personnel of
Yes, group 5
ESI hospital,
sponsored by group 5.
and they were arrested on the same day, 18th
Yes.
July.
18 July.
18th of July 2026, and since then they're behind the bar for last 11 days. And he further submits that in view of the nature of allegation, further custodial detention of the accused person may not be required, and therefore he has contended to allow the petition. Mr. Borthakur, learned additional PP, however, opposed the petition. Para, having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on the record. And it appears that the FIR was lodged on 18 July 2026, and since then the accused persons, and on the same day, the accused person were arrested, and since then they are languishing in jail for last 11 days. But in view of the nature of allegation in the FIR, and also in view of the length of detention, their further custodial detention seems to be unwarranted in the interest of investigation, and accordingly this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 10,000 each with one security of like amount to the satisfaction of the learned CJM Kamru and Gauhati, the accused persons are large on bail.
May I please, your lordship?
Yes.
This is in 483 application. Allegation is that the 5.2 5.2 grams heroin recovered from the kitchen of the petitioner.
When he was arrested,
He was arrested, lordship, more than 100 days. He is behind the bar, lordship.
more than 100 days. Search sheet submitted or
Charge sheet
not?
submitted, lordship.
Not submitted.
Submitted.
Submitted. When?
Charge sheet submitted.
When?
Lordship. 28/5/2026. Page number, lordship, 24.
Search sheet was submitted on 25.
28/5/2026.
He is behind the bar for more than
More than 100 days.
100 days.
So, lordship, section 4.
21B. Charge was framed against him
Yes, lordship. Charge is framed.
under section 21B.
Charge already framed, lordship.
Where is the order?
Shape. Page number 30. To case status of this case.
No, under which provision charges framed? 21B or 21C?
21B.
B.
Let's proceed. 6.26. Allegation is, but as per FSL 5.2. FSL report also there. Proceed. Page number 29. The petitioner is a woman. They have 4 minor children also. One 3-year-old children is suffering from disease, was admitted in hospital.
What is the percentage of heroin in the sample? It is not indicated in the report.
Shit. Yes, they have come for 5.28 grams confirmed.
Where it is mentioned?
Page 29. Description of exhibit.
It is 5.28 gram.
Yes, Lordship. Small
Result
quantity
of
5 grams.
examination where?
Result of the next minus based on color test and high performance clinic. The presence of heroin has been confirmed.
But what is the percentage of heroin there?
Yes, but that is not the.
That is not available.
So he is more than 100 days behind the bar. Intermediate quantity. Lady. Art, Mr.
Yes, sir.
Learned counsel for the accused. And Sapi Borthakur learned additional degree for the stateless complaint. This application under section 483 of the BNSS 2023 is preferred by the accused. Preferred by accused. Zarina Khatun, who is languishing in jail Azut in connection with special NDPS case number 35 of 2026, corresponding to Mikiri Bhetta PS case number 58 of 2026 under section 21B of the NDPS Act since 20th/4/2026. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Ozoy Regon, SI of Police, Boribazar Patrol Post. The allegation against the accused is that she was found in possession of 6.26 grams of heroin in her residence. Learned counsel for the accused submits that the accused is a lady and she has 4 children,
Yes, Lordship.
4 minor children. And she is languishing in jail Azut for more than 100 days. And that the investigating agency, after completion of investigation, submitted charge sheet, and now the case is pending for trial. and that she is ready to face the trial and therefore it is contented to allow the application. Par contra, Mr. Bortaku, learned additional PP, has opposed the petition. Para, having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents plus on record. And it appears that appears from the FSL report, no, appears from the Caesar report, page number,
Page number. Page number 17, 17.
it appears from the Caesar list that 6.26 gram of heroin was recovered from the possession of the accused on 28/4/2026. And the FSL report, which is annexed with the petition as annexure number 6, indicates that the sample contains 5.28 grams of light brown colored powdered substance. And the presence of heroin has been confirmed in the same. Since the investigation has already been completed and search sheet is submitted against the accused and search has also been framed. And since the accused is a woman and has the burden of looking after 4 minor children, this court is of the view that her further custodial detention may not be required. And accordingly, it is provided that on furnishing a bond of rupees 25,000 with one surety of like amount to the satisfaction of the learned special judge NDPS Act, Majoli,
Moregaon.
Moregaon. The accused be enlarged on bail. Accused be enlarged on bail. In terms of above this BA instance, let's go.
Item 4.
May I please your lordship? My lord, the petitioner was arrested on 27 April. My lord, today is 95 days. He is behind the bar. My lord, the page 15 is the FIR. Here, my lord, the 8.08 kg of ganja was recovered, my lord, from the house of the present petitioner. That is the allegation, my lord. And next, my lord, page 20, the charge sheet, my lord. After 1 month,
You were behind the bar for
my lord, 95 days, my lord.
95 days.
And
Here,
charge sheet,
search sheet is submitted.
my lord, 27/5/2026. After 1 month.
Search sheet submitted.
Yes, after 1 month of arrest, charge sheet was submitted.
Mhm.
And after
And,
that,
what is the quantity?
my lord, 8.08, almost my 8 kg, my lord.
Ganja
Ganja, my lord. And my lord, page 25 is charges frame, my lord.
under section.
Under section, my lord, 20B, my lord. And my lord, that very day, my lord, bail also filed, my lord, just rejected, my lord. So I am praying, my lord, since here's the trial, my lord, already succeeded, my lord, on maritime not argue, my lord. An opportunity may be provided, my lord, to face the open trial, my lord. Everything is completed, my lord, but and 9 PW is in the charge sheet, my lord, so it will take some more time, my lord.
Opportunity is to be given to you to face trial.
My lord?
To face trial.
Yeah, my lord.
Now you are not facing trial.
No, I'm saying, my lord, but after open, my lord, I'm submitting this, if the honorable court release, my lord, then without
is
fail,
the-
my lord, regularly will appear, my lord.
Where is the guarantee that if bail is granted to you, you will not indulge in similar activities?
Yes, my lord. My lord. My lord, paragraph 10, my lord.
Hmm?
Paragraph 10 of my petition, page 6, my lord. That the petitioner beg to state that he will make himself available before the learned trial court, my lord, as and when required to appear before the learned court, my lord.
Mr. Portakur, anything to submit?
Otherwise, only my lord, some strict conditions may be imposed.
Heard Mr. Uddin, learned counsel for the accused. And Mr. Portakur, learned additional PP for the state respondent case application under section 480 of the BNSS 2023 is prepared by accused Ibrahim Ali. Who is languishing in jail hazard in connection with special NDPS case number 37 of 2026 under section 20B, which indicate Roman 2, which indicate capital B of NDPS Act, arising out of Bagbor PS case number 33 of 2026, pending before the Court of Special Judge, learned Special Judge Borpeta for this program. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Happy Lark Hato, SI of Police Bagbor PS on 26/4/2026. The sense of allegation against the petitioner is that on 26/4/2026, he was found in possession of 8.085 kg of suspected ganja. Mr. Uddin, learned counsel for the accused, submits that the accused was arrested on 26/4/2026, and for last 95 days he has been languishing in jail as well. He further submits that the investigating agency has completed investigation and submitted charge sheet against the present petitioner, the present accused, and the learned trial court has also framed charge under section 20B against the accused, and that the accused is ready to face trial and he will appear before the learned trial court on each and every day. And under such circumstances, he has contended to allow this application. Per contra, Mr. Portakur has opposed the petition on the ground that 8.085 kg of ganja were recovered from the possession of the accused. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents present record. And it appears that the accused is behind the bar for last 95 days. Investigation is already completed and charge sheet has already been submitted, and charge has also been framed against the accused. In the view of the matter, further custodial detention of the accused seems to be not warranted. And accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 25,000 with one security of like amount to the satisfaction of the learned special judge Borpeta, the accused be enlarged on bail.
I'm deeply obliged.
It will enable to ensure his appearance on each and every date during trial. The learned trial court will be at liberty to impose any condition as it deemed fit and proper.
May I please, your lordship?
Yes.
My lord, this petitioner, he is behind the bar for last 12 days, my lord. He was apprehended only on the basis of the statement of the co-accused. Lordship would find the FIR at page 21, where I have not been implicated. Page 21, this person has been apprehended from his house, Tahir Ali, my lord, and he was apprehended because of the 8 numbers of mobile phone, 8 numbers of ATM card, and cash amount of 82,000 been recovered from his possession, my lord. Page 21. And accordingly, the case was registered, my lord. And subsequently, on the basis of his statement, my lord, I was apprehended also in this case on the basis of his statement, my lord. Now, at this stage also, lordship kindly see the my forwarding at page 54. My forwarding letter is 54. Page 54, the first part is the brief of the FIR, my lord, the same. And the basic allegation lordship will find at 55 against the Taher Ali. And my allegation is that I have converted US dollar into Indian currency, my lord, on behalf of Taher Ali, my lord. And Taher Ali, he is using a portal, my lord, for gambling. That is also indicated in the
Hmm.
now. These all the offenses, my lord, it is up to 7 years, my lord. Here, I have been not served with the notice, my lord. That's mandatory. Lordship knows it. The Satyendra Kumar enters case, my lord. The notice is mandatory when the offenses are 7 years or below. Here, notice is not given to me only with the pretext. There's only one note. Lordship will find at page 56. There's a note just below the grounds of arrest, my lord. Reasons of arrest, my lord. Page 54. After point number 8, there's a note, my lord, by the IO. If the arrested accused person is released as per section 35(3) BNSS, he may hamper
No,
and
Bora, you were referring to page number 50,
6, my lord.
56. Point number?
Point after just below point number 8, there is a note, my lord.
Yes.
That is the only note why the notice was not served upon me, my lord. As required under the law 35, my lord. 3. If the arrested accused person is released as per notice under section 35(3), he may hamper and tamper with the evidence of the case, threatening to the local witnesses, also may abscond, and their production in the honorable court during the trial cannot be ensured. Therefore, accused person was not released on notice under 35(3). So 35(3) was not served actually. It was not served, no denial, but they are not released also on 35(3). So if the 35(3) is not followed, my lord, he has to give a concrete reason why the notice was not served on me on the basis of some facts. It is not only on his assumption. He must give some reasons which is actually exist in the facts that he may abscond. There must be some reasons. His assumption will not do that I may abscond. I may not be produced. It will be difficult. I may temper. But so that notice was not served, and the lordship also knows when the 35(3) notice was not served, when he was produced, it is the incumbent on the magistrate also to give his own reasons, not persuaded by the reasons given by the IO. He has to satisfy his own reason. This is reason given by the IO on the basis of these facts can be acceptable. So 35(3), why there is no notice, the magistrate also forwarding to his custody must give his own reason basis on the facts.
Where is that report?
That is
Order of the
order lordship will find page 58, my lord. Just one line lordship will find there is no reason by the magistrate concerned. He simply says that I am satisfied, my lord. And there is no
Where is that observation?
my lord, 58 starts, my lord. Next 59, my lord. Third para. Further, perusal CR reveals the prima facie incriminating material against the cellular accused person I see with this case. Now next, I have also gone through the forwarding report wherein investigating officer has stated grounds which are found to be satisfactory. This is only his reason. That is not the sufficient, my lord. He must give his own reason why he has accepted the reasons given by the magistrate for forwarding the accused. That is the requirement, lordship, for my satisfaction.
So, in which paragraph of the Satyendra Kumar?
Yes, my lordship, I have given the judgment, my lord. Books also. 2 paragraphs is very important.
Not this one, the book.
Book,
Old
Kitab
one.
Khan, yeah.
That is the new one.
There's a new one also reiterating the same, but the lordship kindly go take up the Satyendra Kumar until page 85.
Yes.
Page 85 of the book.
22, volume 10.
No, this one.
This one new one also.
Come later.
It will come later on, my lord. This is just reiterating the and 85, my lord.
Paragraph number 85.
No,
Page 85, my lord.
Yes.
Para 27, or my lord, 8.2. Page 85, 8.2.
Yes.
The before magistrate authorizes the detention under section 167 CRPC, he also to be first satisfied that the arrest made in is legal in accordance with law and all the constitutional right of the person arrested are satisfied. If the arrest effected by the police officer does not satisfy the requirement of the 41 of the code, now it is 35, magistrate is duty bound not to authorize his further detention and release the accused. In other words, when an accused is produced before the magistrate, the police officer effecting the arrest is required to furnish to the magistrate the facts. This is important. Facts and reasons. My lord, here facts is not missing. And it conclusion. This is also missing for arrest. And the magistrate in turn, this is very important, is to be satisfied that the condition precedent for arrest under section 41 CRPC has been satisfied and it is only therefore he would authorize the detention of an accused. Now 8.3. 8.3 lordship will find the magistrate, this is very important, my lord. The magistrate before authorizing the detention will record his own satisfaction, my lord. Own satisfaction. While here he has recorded the satisfaction of the IO. Maybe in brief, but the said satisfaction must reflect from his order that satisfaction. It shall never be based upon the ipse dixit of the police officer. For example, in case of police officer considered the arrest is necessary to prevent such person from committing any further offences or for the purpose of investigation of the case or for preventing the accused from tampering with the evidence or making inducement, etc., the police officer shall furnish the magistrate the facts, the reasons and materials on which the police officer has reached its conclusion, and those shall be perused by the magistrate while authorizing the detention, and only after recording his satisfaction in writing that the magistrate will authorize the detention of the accused. So here, my lord, the police officer, first of all, he is absolutely silent, wherefrom he has come out with all these satisfaction, and the magistrate, ipso dixit, he has accepted the grounds of arrest of the police. There's no satisfaction of his own in the order furnished, my lord.
Okay, come to the recent decision.
My lord, in the recent decision also, this is more important, my lord.
Paragraph number.
Paragraph 15. 15 is that they have the earlier has been 2026 SCC 162. Paragraph 15 is very important, my lord. Finally, it is submitted that as section 35 BNSS 2023 and ratio of the judgment of the Anes Kumar and the Satyendra Kumar Amrit themselves clearly provided and specific exception where arrest is permissible. So arrest is permissible only in case that they have to give a reasons. Now, Lordship, kindly turn to the last paragraph, discussing everything, my lord, again. The finally 27 to 31. The new 27, we have already clarified the position qua section 35(6) of the BNSS in our earlier order dated so, wherein it has been stated that even assuming that the person to whom the notice under section 35(3) of BNSS has been issued fails to comply with the terms of the notice, is unwilling to identify himself, and arrest is not a matter of course. Even, my lord, here said that even 35 notice may be mandatory, it may be served, even then arrest is not mandatory, my lord. Here it goes further, my lord. this case, my lord, even the notice was not served.
Hmm.
No reason, but here, now Supreme Court has come with a clarification that even if the notice also has been served and even the accused fails to disclose, even then his arrest is not mandatory. We also clarified that the earlier decision that the procedure concerned the 35(6) BNSS 23 has been introduced the touchstone of Article 21 of the Constitution of India. These inbuilt the safeguard and required to be complied with the police officer in letter and spirit. Now, ultimately, my lord, 33. On the basis of the interpretation given by us, we conclude as follows. Now, this is more important, my lord. 33. An arrest by a police officer is mere statutory direction which facilitates him to conduct proper investigation in terms of the collection of the evidence and therefore shall not be termed as a mandatory. Consequently, the police officer shall ask himself the question as to whether an arrest is necessary or not before undertaking the said exercise. For effecting the arrest qua the offences punishable in imprisonment 7 years, the mandate the 35(1)(b)(1) of BNSS, along with any of the condition mentioned in the 35(1)(b)(2) Roman 2 BNSS and must be in existence. This being D. A notice under 35(3) BNSS to an accused or any individual concerned qua the offences punishable with 7 years is a rule. Now this is made in as a rule. So 35(3), it's a rule. Earlier,
Hmm.
it was held that yes, some cases there may not be 30 notice, but you can arrest, providing you have a solid reason for arrest. But
Okay.
here, even the notice was not served to me, my lord.
Okay.
In the checklist also, there is nothing.
Okay. Mr.
Your Lordship,
Porter.
first of all, my lord, regarding 35(3), my lord, I will point out, my lord. Initially, yes, in this case, my lord, because the offences of my lord cybercrime and financial fraud, initially one Tahir was arrested, and on the basis of the source information, residents of the all these my lord activities were going on from the residents of the Tahir Ali, and thereafter on being searched the residents of the Tahir Ali, those my lord 8 numbers of ATM cards and my lord other incriminating materials found.
Telephone.
And thereafter, my lord, your lordship forwarding report, your lordship at page 55, ground number 3, my lord,
Hmm.
page 55. During investigation, it has been revealed from the statements of the already arrested accused persons, statement, my lord, namely Tahir Ali and Quran Ali, as well as other materials, not only statement of the accused, my lord, as well as other materials collected during investigation, that the accused person Ariful Kobir, the present petitioner, knowingly assisted them in converting USDT cryptocurrency obtained through illegal cyber fraud activities into Indian rupees. So this is that not only on the basis of the statement of the co-accused, but other materials is there. And regarding 35(3), and my lord, yes, regarding 35(3), admittedly, my lord, your lordship, from the forwarding report, that note is there, that's why 35(3) notice was not started. That, my lord, that is already pointed out by my learned senior. I will not read again, my lord. If the arrested person, my lord, that is there in the note sheet, page 56. Now, my lord, regarding thereafter, my lord, it is the duty of the, my lord, magistrate of the trial court to, on the basis of those facts, reasons, and materials, my lord, submitted by the IO, to satisfy himself that there is ground for, my lord, remanding the accused person, my lord. Now, my lord, your lordship, from the while submitting not only the forwarding report, IO, while my lord, there is my lord retained grounds of evidence, IO also submitted the case diary to the my lord magistrate, my lord. So in the case diary, my lord, although all the other materials are there, my lord, here in this forwarding report, your lordship, at page 54, my lord, initially part, brief facts of the case. This is the detailed facts of the case, my lord. And thereafter, my lord, grounds of arrest, detailed grounds of arrest is there, my lord. And next, my lord, reasons of arrest, not only grounds of arrest, reasons of arrest is also there. And thereafter, my lord, reasons for seeking 7 days police custody. So every details is there, grounds, my lord, reasons for arrest, grounds of arrest, and thereafter, my lord, admittedly note that why 35 was not served to the accused, that is also there. Now regarding satisfaction of the, my lord, learned, magistrate of the trial court, my lord, well, he has specifically in the, my lord, order your lordship. My lord. I have also gone through the forwarding report, wherein the investigating officer has stated grounds which are out. This is not the satisfaction of the IO. The, my lord, line itself, my lord, reflected is the satisfaction of the magistrate. So on the basis of those, my lord, reasons of arrest, grounds of arrest, my lord, all other ones. So we satisfied that yes, in this case, it must be granted. So thereafter, on being satisfied, my lord, he was, my lord, remanded to 7 days police custody. My lord. So everything has been complied by the, my lord, IO by the prosecuting agency. So my prayer, your lordship, before your lordship, considering that this is a matter of, my lord, financial cyber activity also there, my lord. So city responsible. Using CD, what are there in that CD, my lord, supporting?
No. Mr. Bora has not argued on the merit of the case. He has argued on the procedural
35(3).
requirement.
35(3) also, I have pointed out that, yes, 35(3), there is a note of the IO is very clear. Thereafter, my lord, not the forwarding report in detail, facts, reason, grounds of everything is there. Thereafter, my lord, learned trial, learned magistrate has.
No, the question is whether the forwarding report satisfy the requirement of the procedural aspect laid down by Supreme Court in the case of Satinder until or not.
Regarding whether there is some what right now it is the rule is that you can now 35(3), although that grounds not only sufficient that needs to be served. Regarding that aspect, my lord, till now I have not gone through that, my lord. That, my lord, only mentioning the grounds of arrest, why 35 did not serve, my lord. Earlier, my lord, point was there that in case if, my lord,
My-
35 is not served,
my only
ground satisfying that why
Yes.
35 did not serve, that was sufficient.
IO has given some, he has simply said that there is no 35(3).
Mm.
But why 35(3) is not given,
Mm.
there is no indication by the magistrate. Is only that aspect, my lord.
Mm.
Not only the police, magistrate also has to satisfy
Mm.
that the reason given by the police for not serving the 35(3), that must exist in the order. Here in the order, he simply says that the investigating officer grounds are found satisfactory. Grounds of arrest is different. Grounds of not serving the 35(3) is a difference. He is mixing up my learned friend is mixing up both. Grounds of arrest is a different, reasons of arrest is a difference, but the not serving the notice, that is absolutely different aspect. Here I am not serving the notice. You can give hundreds of reasons for arrest, but the why you have not served the notice, there must exist some reasons, and that reasons must follow from the facts of the case. Here also, grounds of arrest can be substituted from various reasons, but the why you have not served the 35(3), and the magistrate also has to indicate in the role that the yes 35(3) notice was not required in this case. That satisfaction he has to come up with it, and the new judgment, it has reiterated and affirmed the judgment of the until. Rather, it has enhanced the state that this is a rule. It cannot bypass.
Okay.
That's all.
We will pass the
Oh,
order.
problem.
Correct.
Thank you.
Number 6.
এই রেকর্ডটো ডাইরেক্টলি সার্ভার দিয়ে যেখানে অর্ডার দিয়া না যায় সেখানে সার্ভার ডাইরেক্টলি দিব তাতে দিলে কালেক্ট হয়ে দিয়ে oh
Petition released to one day I defaulted my lord, and on that day my lawyer has taken steps, but learned court below has issued non-bail warrant for same day. My lord, what happened? This is raised FIR of 2010. Case was charged in 2016 and charge frame 2018. Thereafter, from 2018 to 2026, 5 witnesses out of 8, 5 witnesses were examined. 2 were dispensed because they are not turning up. Now 3/8 is the date for final hearing, my lord. My lord, I am now 83 days behind the bar, my lord, because my lord, I take your lordship page, kindly peruse page 97, my lord.
Okay, you are behind the bar for last 83 days.
83 days.
And your reason behind the bar, keeping
Yes.
you behind the bar is
Earlier, my
you have
last 9
defaulted
years,
one.
we are regularly appeared in the court. During COVID or except COVID period.
You
Now
have-
that I have sold out our property even because for to face the case
No,
for
no,
9 years. Now
Mr.
we went to Arunachal. We
Mr.
asked our
Biswas.
lawyer, you take time because we have to earn money.
Mr. Biswas,
Yes, but
you have defaulted only on one date.
no, but several days my lawyer, I did not come, but my lawyer taken steps. On last occasion, page 97, my lord, please peruse, my lord, please peruse 97.
Yes.
Accused Lazam Busumatade and Louis Nazari are absent. Seen the petition filed on their behalf, stating that they could not appear before the court today due to some unavoidable circumstances. Heard both sides. Peruse the case record and as the ground stated in the petition is vague, the petition stands rejected. Issue non-bailable warrant of arrest against these two. Thereafter, my lord, we were taken into custody on my lord 8-5. From 8-5, we have 5 dates we have taken for evidence, but no witness has come. And on that date also, no witness was turned up. Last 9 years we are appearing and we are fighting this case from 2018, 2010, my lord. Now 2026. Almost 9 years completed, my lord. We pray that our bail may be considered, my lord, and 3/8 is the last day of final order, I have come to know. 3/8 day after tomorrow. Monday, my lord.
Yes, Bhattagar.
Monday session.
Monday to release I will get acquittal because out of 8 witnesses, 5 have not told that if I have annexed the order, all the evidence portion to have been expanded, dispatched with by the court below. Only one remain. On that day, it will be hard. Court is going to pass the order, final order on 3/8.
Of the judgment. Court will pass the judgment.
Pardon?
Court will pass the judgment.
Yes, on that day. I came to know this morning. Yeah. Otherwise, you would do the petition or otherwise, the 3/8 is the last day of the court.
Present petition is being clearly issued by your NBW.
Yes, I have submitted. But from first day, very first day, your lordship knows our own High Court as my apex court. First day, non-bail, in spite of the fact that my lawyer has filed the application. And court work was not held up because there are no witness also came up on that day. My
No,
your
no.
lordship will appreciate. Last night, from 2010, we are facing the trial.
No,
In a
whether
false
the,
situation.
whether the evidence is completed.
Now, my lord, out of 8, I will show 5 have been examined, they have investigated, 2 have been dispensed with. Now 1 remain. On that day, if you don't come, they will take court will take it, note down our statement. Because the CRPF people are not coming from different places. From 2010 matter, whether they are in service or how much. That is the problem to procure the witnesses. 5 have not implicated me. I have annexed the evidence portion also. Kindly give me an opportunity, my lord, to get appear on the to release on that bail.
No, if you again defaulted, then
3/8 is the final thing. I assure you, Lord.
maybe on
Yes.
that day, if the remaining witnesses did not turn up, no, will not turn up then.
But even that I will appear regularly. You give me any condition in directing. If one day default, my bail will be automatically cancelled. One day default.
He will never appear. Those are
I will appear. I assure. I undertake the responsibility.
of terrorist group.
No. Yes, you could not. My lord, even IO said, I do not know who has seized those explosives. From whom it was seized. I have given the evidence.
Okay, we'll see and pass the order.
Kindly, madam. Kindly, madam.
Madam Servant.
Wait, please, my lordship.
Mm.
My lord, there is a bail application for the present accused person under section 483, my lord, arising out of Barpeta PS case number 77 of 26, registered under 21.
Okay, since when you are behind the bar?
Today is, my lord, 139 days,
139 days.
my lord.
What is the quantity of
11
contraband substance
14.
recovered from you?
11.14 kgs of ganja,
11.14 kg of ganja.
my lord.
From where this quantity of ganja were recovered from your possession,
From allegedly from my possession, from a bag, your.
from your residence or
No, my lord. While I was coming from a particular place, they have created a Naka checking. and
which
while I
place to which place?
was- My lord would see the FIR. I reached Barpeta to Dolasal Road near Shiv Mandir and set up Naka to interpret the said peddler. After about 40 minutes, around 12:50, the police team saw a person walking from Tarabari side towards Nogao Barpeta.
Okay.
Page number 20, my lord.
Whether investigation is completed,
My lord, investigation is completed. Charge sheet has been given.
search it submitted.
My lord, charge sheet number 96 of 26. dated-
Charge was framed against you
My lord, charge has been framed
under section
under section 20B2B, my. Annexure 11, my lord, page number 50.
page number
50, my lord.
yes, Border Code.
Any short that may be fixed one. Any short
Or
that.
otherwise,
Sorted for.
TCF one.
Is it necessary? Search it is submitted. Search is in print. Is behind the bar for 139 days.
Yes, one.
Let him pass trial. Okay, we'll pass the order.
my lord.
Next.
Deeply obliged, my lord.
Your Lordship. Lordship, this is a bail under section 483 of BNSS. The petitioner is behind the bar for 47 days, Lordship. So, Lordship, kindly CD may be called for.
This is under PC Act. Okay, you produce the case diary then. Okay, you may file your reply, but produce the case diary on next day. Third Miss
Miss E. Thaklari.
learned counsel for the accused, and also her Miss Kumari learned standing counsel for the CBI. This application under section 483 of the BNSS 2023 is prepared by the accused for granting bail, who has been languishing in jail as in connection with FIR number RC 0202026A 0003 under section 7 of the Prevention of Corruption Act 1988. After hearing learned counsel for both the parties, it is provided that the learned standing counsel for the CBI shall produce the case diary before this court on
Lordship, 7th of August.
7th of August.
7th.
But I request for 13 or 4th, 13th of August.
Lordship, on 12th August, it will be 60 days. So, before that, Lordship.
Then
request for 7th.
Not required, then 10th I may not be there, 7th. is-
7th.
7th.
Seven.
Okay, 7th. In the meantime, Ms. Kumari may file her objection.
Deeply obliged, Lordship.
May I please, your Lordship, is in regular bail application, Lordship. Petitioner is behind bar 36 days, Lordship. Case was tested.
36 days.
Yes, Lordship. Caline PS. Case number 69, your Lordship. Case was tested under section 21B, Lordship.
Hmm.
The heroine may not want 77.
CD may be called for, Lordship.
Search it submitted?
No, Lordship.
Schedule.
CD
Search
may
it
be-
submitted?
No, Lordship.
No.
Not.
Produce the case diary then.
Schedule.
Third, Mr.
Yes, Hussein.
Learned counsel for the accused.
Satisfied.
This application under section 483 BNSS 2023 is prepared by this. Hassan Ali. Oh, okay. Order Hassan. CD on
और मतलब 30
13 sorted.
sorted मतलब on 10
No, you say already 36 days
36
elapsed.
7 then मतलब 7
Seven. Okay, 7.
Hello, please.
Please, your lordship. Lordship, kindly pass over this matter for time being.
Time being.
May it please your worship. Sir, my lord, revision against conviction, my lord. Trial court convicted the petitioner by 6 months, my lord, along with fine, and against the order, my lord, I have filed an appeal, my lord, and the affiliated court, my lord, upheld the conviction, my lord. So as this stage, my lord, let the notice may go to the respondent, my lord. It's a matter and a case, my lord.
Heard Mr. Borua, learned counsel for the petitioner. In this petition under section 442, read with section 438 of the BNSS 2023, the petitioner has challenged the judgment and order dated 38/8/2025 passed by the learned Chief Judicial Magistrate Srirang Kajolgaon, passed in NICR case number 29 of 2023, convicting the petitioner and sentencing him to pay a fine of rupees 12 lakhs to the respondent herein, and also sentenced to undergo simple imprisonment for 6 months with 6 months, and in default of payment of fine to undergo simple imprisonment for another 6 months. And also the judgment and order dated 10/12/2025 passed by the learned Sessions Judge Srirang in criminal appeal number 32 of 2025, by which the learned appellate court has dismissed the appeal and thereby upheld the judgment and order of conviction passed by the learned Chief Judicial Magistrate Srirang Kajolgaon in NICR case number 29 of 2023. Peruse the petition and the documents placed on record, and also peruse the interim judgment and order dated 38/8/2025 passed by the learned Chief Judicial Magistrate in NICR case number 29 of 2023, and also the judgment and order dated 10/12/2025 passed by the learned Sessions Judge Srirang in criminal appeal number 32 of 2025. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Recessal call for the record from the learned. Call for the TCR from the Court of Learned Chief Judicial Magistrate Srirang Kajolgaon, and also the record of learned appellate court in appeal number
32 of 2025.
32 of 2025. List the matter after 4 weeks. I score
For suspension of sentence, my lord.
heard Mr. So learned counsel for the applicant. This interlocutory application is preferred under section 430 within bracket 1 of the BNSS 2023 for suspension of sentence passed by the learned Chief Judicial Magistrate Srirang Kajolgaon in NICR case number 29 of 2023. Peruse the application and documents placed on record, and also peruse the judgment and order passed by the learned Chief Judicial Magistrate dated 30th-8-2025, passed in NICR case number 29 of 2023, which has subsequently been affirmed by the learned Session Judge Sirang in criminal appeal number 32 of 2025. Mr. Borua, learned counsel for the applicant, submits that connected criminal revision petition has already been admitted by this court, and as such, there is a requirement of staying operation of the impugned judgment. An order dated 30th-8-2025, passed by the learned Chief Judicial Magistrate in NICR case number 29 of 2023, and also the judgment. An order dated 10-12-2025, passed by the learned Session Judge Sirang in criminal appeal number 32 of 2025. Further, having considered the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, it is provided that the impugned judgment and order of conviction dated 30th-8-2025, passed by the learned CJM Kazolgaon Sirang in NICR case number 29 of 2023, and the judgment and order dated 10-12-2025, passed by the learned Session Judge Sirang in criminal appeal number 32 of 2025, stands state till disposal of the connected criminal revision petition. In terms of above this, IA stands closed.
Obligement.
Well,
Made please, your lordship. My lord, the similar matter, my lord. Trial court convicted by 6 months, my lord, along with fine, my lord, and thereafter, my lord, file an appeal. That was, my lord, order of the trial court was, my lord, upheld, my lord. Rising out of, my lord, and act.
item 30.
Here also IA is there.
Yes, my lord, I there. Obligement.
Yeah, please, Lordship. Lordship, matter may be passed over for time being. My senior lives in another. Much obvious.
Item 14.
May I please? The revision against conviction, my lord, under 138 NI, I have been convicted by the trial court. And in appeal, my lord, my sentence was modified, my lord. So, notice may be issued, my lord.
Same order.
IA is there, my lord, for suspension of sentences.
How sentence is modified?
Earlier it was 9 lakh fine, my lord. It was modified into 7 lakhs. And 6-month conviction has been modified into 3 months. Okay.
Item
Obliged.
16.
May I please, Lordship? I'd like to hear in this case, Lordship, the complainant, Lordship, the allegation in the complaint is that while he was coming towards his residence, he lost some checkbook, signed checkbook, check leaf, and subsequently, Lordship, one of the check leaf has, according to the allegation, has got by the present petitioner, accused petitioner, and he has deposited the check for encashment of rupees 6 lakhs.
Mm.
That is the allegation.
And I. Thereafter,
Well, FIR,
you have been convicted.
well, that is the allegation that I have got that check, one of the check, and deposited for withdrawal of rupees 6 lakhs. That is the allegation in the FIR, Lordship. Kindly come to page 11. FIR is, Lordship, relating to pertaining to 2011 allegation, 2010 allegation. May I read, Lordship? Page 11.
What is this? The proceeding is pending.
Well, Lord, that proceeding has already been completed. I filed, in fact, Lordship, that check was given by the complainant to the petitioner for
No, after completion of that proceeding, what happened?
my lord, that he has been convicted
Convicted.
for
Thereafter, you have preferred appeal.
appeal dismiss,
Appeal
revision
dismiss.
file, revision is also dismissed.
Hmm.
So everything is in favor of the accused. My lord, that check was given for the for
No,
to
no,
discharge
everything was in favor of,
the accused petitioner.
in favor of.
Yes. I have
Then
an
why you are preferring this?
My lord, this FIR is lodged by the lordship, the complainant, who has given the check to me.
Where is that FIR?
FIR, lordship, page 11. This is the complaint lodged before the chief judicial magistrate, subsequently registered as PS case, lordship. Page 11, lordship. May.
Okay, Mr. Locker, no, Portakor, what is the case diary of this Katigora PS case number 138 of 2011? Whether investigation completed?
Charge sheet submitted. I have an charge sheet.
Where?
Page, lordship, 18. Page 19 is relevant. What the investigation has found in the investigation, during the course of investigation, there is no materials in the charge sheet. Only during the investigation, page 19, lordship.
During investigation?
During investigation, a prima facie case under section 403, 420, 423 IPC has been found, well established against the accused Abdul Rahim, who has been arrested and released on bail as per court order. So I beg to send him to for face trial and said section of law. The PW noted in column.
What is this? The proceeding is pending now.
My lord, now the proceeding is pending. I have annexed all the order, lordship, that someone has been issued and I entered appearance.
Okay. Okay, let the trial court record come.
And till then, lordship, further proceeding may be
Let the record come on that day. We will consider you.
I have, lordship, in prima facie case, lordship, because in the trial in the NI proceeding, lordship, the complainant has
No,
lost.
that's all right.
He has been convicted. for 2 years.
Immediately receiving the record, we will consider your pair on next date.
My lord, otherwise, lordship, there is no.
When the next date is fixed.
Next date, lordship, on 7/9.
Heard Mr. Khan, learned counsel for the petitioner in this petition under section 528 of the BNSS 2023. The petitioner has
8/9.
right for causing the peer case number 2363 of 2024 arising out of category PS case number 138 of 2011 pending before the Court of Learned Judicial Magistrate First Class Kasar at Silsar. Where is the petition and the documents placed on record? After hearing learned counsel for both the parties, it is provided that RECI shall call for the scanned copy of the record of PRC case number 23633 of 2024 arising out of category PS case number 138 of 2011 pending before the Court of Learned Judicial Magistrate First Class Kasar Silsar. Fixing the matter on. No, Lama. Notice.
The next date is 8/9.
Also issue notice to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Portakor entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. list the matter on sorted. 28 August. Interim period of the petitioner will be considered immediately after receiving the record from the learned trial court.
Item number 17. Requested to pass upon Mr. for timing. Oh.
SCNCB.
Okay, timing.
May I please it, your lordship? Present application, lordship, invoking inherent power of this court, lordship, for challenging asylum FIR dated 26/11/2026 and subsequent charge sheet and the present proceeding, lordship. The arising FIR annexer A, lordship, page number 14, annexer A, page number 14.
What is the ground?
Ground is that, your lordship, that is the consensus relation was done between the parties at the time, lordship. But subsequent instance, they mutually agreed and affidavit has been done. The informant itself swearing the affidavit, and she is not willing to pursue the case before the learned trial court. In the event, although 376 is there, no ingredients has been found in the charge sheet that the 376 is there, but only the consensus relation, and the informant has roaming with the accused petitioner with her consent, and she is the aged lady, and she know, and whenever she stated that she came to the hotel room number 14 and 15 times, that is her consent. But the subsequent instance she
Okay,
stated in the
at what stage the proceeding is pending?
in initial stage, learned district session judge has initiated the criminal proceeding against him, and the accused petitioner has
Charge has been framed. Charge framed.
Charge has already been framed. Thereafter,
Witness has
learned
examined.
judicial magistrate has
Witnesses examined.
no witness has been examined in this case.
Okay, let the trial court record come.
Yes.
Heard
Can-
Mr. M.
can you
Soikia,
note
learned counsel. for
Interim
the-
protection may be granted.
Learned
Stay
counsel
order
for
may be
the
granted.
petitioner. And also heard Mr. P. Borthakur, learned additional PE, authorized respondent. This petition under section 528 of the BNSS 2023. The petitioner has applied for quashing the FIR dated 26/11/2026 arising out of Kazalgaon PS case number 184 of 2025 under section 318 within bracket 4 296 stroke 351 within bracket 2 stroke 64 BNS 2023 corresponding to session case number 30 of 2026 pending before the Court of Learned Sessions Judge Sirang. Where is the petition and the documents plus on record? That notice be issued to the respondent, returnable in 4 weeks, that be taken by speed post and also by usual process upon respondent number 2. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Registrar call for the record of session case number 30 of 2026 pending before the Court of Learned Sessions Judge Sirang, fixing the matter on number and notice of 4 weeks.
Your lordship, stay order may kindly be granted, lordship. Kindly be produced annexer D, page number 29. That is the affidavit itself done by the informant side, and in para number 6-7, she clearly stated that she does not wish to continue the case. May I please to read para number 6 into her affidavit? page number 31, Lordship, kindly be perished. That in the said agreement, the husband of the first party, namely Foilo Basumotai, and second party, namely Kiran Basumotai, has further declared that they are not willing to pursue the case against each other. Accordingly, Kiran Basumotai has stated that she does not pursue the case which is presently been pending before the learned judicial magistrate first class Kajolgaon, Srirang. As well as in another paragraph number 7, that the declaration, paragraph number 7, that the declaration has been made the parties voluntarily, and the second party, being a competent person, has willing to stated that she does not wish to proceed the case against the first party. Accordingly, both parties are executed. This declaration has documented evidence which may be produced in future before any competent court before the honorable.
That's all right. The question is whether the informant
Yes.
victim has put her signature over this affidavit or not, we do not know.
Yes, yes. She has duly been Kiran Basumotai second party into the affidavit. Even in these cases, I implemented her as party respondent number, so notice maybe goes to her. In the meantime, proceeding may be stayed, your lordship. Even our honorable Gauhati High Court and other number of judgment of
No,
honorable
we are
Supreme Court,
not
the
rejecting your
proceeding has
prayer.
been quashed on basis of the mutual agreement. In the event, although 376 is here,
No.
there is no ingredients. And it will not affect to the our society.
Mr.
Lordship.
Stoikia,
Yes, your lord.
this is an agreement. This is not an affidavit. Are you sure that this signature appearing here is of the informant?
Yes, yes. Kiran Basumotai in the first.
Are you sure
paragraph
that
stated
this signature was put by the informant here? If you can give assurance, then we can stay. But I have to record your statement.
Kiran Basumotai, signature of the second party.
Sure.
Sure. Kiran Basumotai.
You're sure?
Informant.
No, that's all right. Name is Kiran Basumotai, but are you sure that this signature is put by the informant?
Absolutely, in presence of the notary public, both the parties are present at Kamrup, Gauhati. In the meantime, I implemented her as party respondent number 2. Your lordship, notice may be
On next that we
her.
will consider it. After hearing learned counsel for both the parties, it is provided that interim pair of the petitioner will be considered immediately after receiving the record from the learned trial court. Please the matter after for
Deeply.
May I please, your lordship? My lord, transfer petition, my lord. My lord, the petitioner, my lord, filed this application for transfer the case from Gauhati to Huzai, my lord. Cause of action, my lord, happened at Huzai, my lord. The petitioner is hailing from Huzai. The wife of the petitioner, she is from Kachar. And marriage was solemnized at Huzai, my lord. And they started, my lord, I started to live at Huzai, my lord. And now the opposite party, my lord, the wife, she filed a maintenance case under section 144 at Gauhati.
Presently, where she is staying?
Now she is staying at Nagaland, my lord.
Are you sure?
With her father, yes, my lord. After 3 months of marriage, my lord, she, my lord, go back to her.
Huzai will be nearer to Dimapur.
Now she is, yes, my lord, Dimapur.
Heard, Mr.
Yeah.
Learned counsel for the petitioner. And this petition under section 447 of the BNSS 2023, the petitioner has tried for transferring FC criminal case number 505 of 2025 pending before the Court of Learned Principals as Family Court number 1, Kamrup M. Gauhati. 2. The Court of
Principal Judge,
Pardon?
Family Court Kamrup Metro Guwahati. To my lord Hosai. Hosai my lord district judge. There is no family court.
To any competent court of Hosai, Shankardev Nagar. Learned counsel for the petitioner submits that the petitioner is the husband of the respondent, and the respondent has instituted one FC criminal case number 505 of 2025 before the learned principal judge family court number 1 Kamrup M. Gauhati, and that the petitioner is residing at Hosai, and the marriage was solemnized at Hosai, and after the marriage, the petitioner and the respondent live together as husband and wife at Hosai, and as such, the court of competent jurisdiction in this matter is the court at Hosai, and under such circumstances, he has contended to allow this application. He also submits that the petitioner is, no, the respondent is presently staying at
Dimapur.
Nagaland with his with her father, and it will be nearer to Hosai also. Where is the petition and the documents placed on record? Let notice be issued to the respondent returnable in 4 weeks. The be taken by street post and also by usual process within a week from today. List after 4 weeks, and considering the submission of learned counsel for the petitioner, and also considering the facts and circumstances on the record, further proceeding of FC criminal number 505 of 2025 pending before the court of learned
Principal judge family court number
Learned
1 Kamrup Metro
principal judge family court number 1 Kamrup M instance state. List of the products.
Oblige.
May I please the lodge? Basically, lawsuit is revision. This is a revision petition lawsuit. It's the trial court lawsuit convicted this petitioner under section 323 and 225. Subsequently, in appeal lawsuit, this was modified and punishment has been lawsuit reduced from 1 year to 6 months. Basically, lawsuit, the findings of both trial court as well as the appellate court is in presumption lawsuit, and there is no independent witness at all lawsuit to establish the allegation lawsuit. However, when the trial court as well as the appellate court also has relied upon the evidence of only the doctor's evidence. On the basis of the lawsuit, doctor's statements, it was held that lawsuit this petitioner was this victim was lawsuit treated by this petitioner. But you'll see the findings of the appellate court at page lawsuit 66. Page lawsuit, I can just have page 65.
Okay, let notice go at this is. We'll also call for the record.
Lordship.
Heard Mr. Kolita, learned counsel for the petitioner. In this petition under section 438, stroke 442, rated section 528 of the BNSS 2023 is referred by the petitioner, namely Sri Montu Das, challenging the judgment and order dated 25/5/2026 passed by the learned Session Judge Nalbari in criminal appeal number 15 of 2024. Full stop. It is to be noted here that by the impugn order dated so the learned Session Judge Nalbari has modified and convicted the petitioner to undergo SI for 6 months with fine of rupees 2,000 with default stipulation in PRC case number 1292 of 2019, passed by the learned. Who passed the order? Conviction order?
Condition order CJM lordship, Chief Judicial Magistrate,
Chief
Nalbari.
Judicial Magistrate, Nalbari, by judgment and order dated 13/6/2024. There is the petition and the documents placed on record, and also peruse the impugned judgment and order dated so and so passed by the learned session judge, and also the impugned judgment and order dated so and so passed by the learned Chief Judicial Magistrate, Nalbari. Issue notice to the respondents returnable in 4 weeks, shall be taken by speed post and also by usual process within a week from today. Recess will call for the record from the learned courts below. And further, considering the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, operation of the impugned judgment and order dated 13/6/2024, passed by the learned Chief Judicial Magistrate in PRC number 1292 of 2019, and also the impugned judgment and order dated 25/5/2026, passed by the learned Session Judge Nalbari in criminal appeal number 15 of 2024, stands state till disposal of this petition.
Lodge.
List of 4 weeks.
Lodge. Obliged.
May I please, your Lordship?
Yes.
Lordship, this criminal petition filed under section 528 of NSS, all corresponding section 482 CFC, for quashing of this impugned summon. That is, my lord, time to time they issuing this summon under section 67 of NDPS Act. That is page 17, my lord. Page 17, Lordship, kindly have a look. This notice was issued on 16/3/2026 by the respondent number 2, and in connection with the crime number 10/2025. But this summon, my lord, has not supported with this copy of the crime, and there is no any indication whether I am being accused or witness. And so far, one of Supreme Court different judgment saying that this statement, my lord, recorded under section 67 of NDPS Act cannot be used as confessional statement in the trial of an offense under NDPS Act.
No, that is there. But you
but
are
push-
not sure whether you are witness or accused in this
accused.
matter.
And this so far crime noted here 10/2025, that copy also not furnished. So how I can know that whether I am well acquainted with this case? Because this section saying that examine any person acquainted with the facts. So whether I am acquainted, how I can ascertain myself? And so far, my lord, Article 20 clause 3 is concerned. If I am accused, my statement cannot be recorded. I cannot adduce my evidence against my offense, my lord. There is also violation of the act. So, my lord, humble submission.
So the question is whether a police officer can record your statement.
When
No.
any person acquainted with the
when
facts.
when you yourselves not certain whether you are an accused or you are one witness in this matter.
So let them furnish the copy crime so that I may ascertain what is the allegation brought in this case, my lord. Otherwise, my lord, without indicating anything against me, this summon issued. So I am being surprised why this notice summon issued.
Coming to the issues raised by my friend, I would just like to point out one primary aspect of the matter.
Hmm.
Lordship will come to page 17 for a moment.
17.
Page 17.
Yes.
Lordship will see to whom it is issued.
Hmm.
He is from Nagaland, Dimapur.
Hmm.
His affidavit is from Dimapur.
Hmm.
The notice was served at Dimapur
Hmm.
from Delhi. How can he file a petition out here? Although it is a Gauhati High Court, it ought to have been before the Kohima bench. First. Secondly, now he also says, I am a permanent resident of Dimapur, but just for a few days for some business purpose, I am now in Gauhati. That will not help him.
Hmm.
Secondly, Lordship will see page 18 for a moment.
Hmm.
Now, what has fallen from my friend would not be correct because of page 18.
Hmm.
Lordship will see this relates to some NPS medicine. And they want the details, how he has purchased it, the challans, ledgers, invoice. He is not on that. So it is apparent that the medicines were sold from his concern.
Hmm.
The authorities want to know how he has purchased it. He has given a reply to the authorities, but he has not taken up this issue. He is only on the aspect of page 17. But if your lordship will come to point 2 at page 18, it is very clear what the authorities want.
Hmm.
He is not addressing that point, lordship.
Hmm.
Now, Lordship, I made a reply. So far, this first notice is concerned. And after receiving this notice, they have not been compliant. So what I asked here in the notice, my lord, page 19, I made a reply against the first summon. And
so, no, Mr. Bhuya, admittedly, you were residing at Dimapur.
Lordship, but presently I have narrated in my case, my lord, here. I have narrated in my cost title also.
No, your business establishment is at Dimapur.
Yes.
Dimapur.
Dimapur, my staff is there dealing, and now presently I residing so many times here, resident of house number 103, Joymati Nagar, and partial cause of action arise. So far, the reply notice also posted from the GP of Gauhati. So partial cause of action also there because I am presently residing in Gauhati. And
No. You see, if any offense is committed that is in Dimapur, Nagaland.
The question of offense committed does not arise because so far someone is concerned, here there is no indication whether I involved such offense. So far, crime number 10/2005 is concerned. So my humble submission, my lord, the interim, my lord, this copy of this crime may furnish, my lord. Then if something is there, my involvement, I will
No. Before issuing any order, before passing any order, you have to satisfy this court that this court has the jurisdiction.
The jurisdiction, my lord, there is a bench in Nagaland, my lord. But so far my present address is concerned, and so far my
No,
reply
presently
also.
you are residing at Gauhati, but it does not confer jurisdiction upon this court because someone was issued to you at the office. To your office situated at Dimapur, and it was issued from Delhi.
Not in my name.
Gauhati.
Not in my name, my lord. Director, proprietor of Drug Law Pharma Surgical. But I am not named in the summon.
Who is the director of this Drug Loft Pharma and Surgical?
No, I am the proprietor, my lord.
You are the proprietor.
Proprietor. But name is not there. Proprietor may be changed time to time.
Better you withdraw this petition and file it before the Kohima bench.
Or may transfer this case, my lord,
Pardon?
or may judicial transfer, my lord.
No, this court cannot transfer this
Transfer
case.
the bench.
That is a administrative function. You may file an application before the Chief Justice in administrative side.
That's right. Otherwise, my lord, so far my present address is concerned, and so far reply made from Gauhati GP also partial cause of action in Gauhati. my lord.
No.
So on
no.
that ground, it is maintainable.
No.
Otherwise, I have to approach before the bench, appropriate bench.
You withdraw this petition and file it before the Kohima bench.
Lordship. Lordship may withdraw liberty to file with your bench.
Heard Mr. Bhuya, learned counsel for the petitioner, and also heard Mr. Chaudhary, learned Deputy Solicitor General of India. You are appearing as a
Deputy.
standing counsel.
Deputy.
Okay. Come senior advocate assisted by Ms. L. Devi, learned counsel for the respondent. Mr. Bhuya, learned counsel for the petitioner, submits that he may be allowed to withdraw this petition with a liberty to approach the appropriate bench of this court situated at Kohima. Accordingly, taking note of the submission of Mr. Bhuya, learned counsel for the petitioner, he is allowed to withdraw this petition with a liberty to approach the Kohima bench by filing an appropriate petition.
Lordship, one point may note kindly, my lord, regarding assailing the summon dated 19/6/2026.
No,
if
unless this court has jurisdiction,
compared to other
no
side,
such observation.
and accordingly withdrawn.
Yeah, 19.
Obliged.
Now, may I please, your lordships. This criminal petition has been filed, your lordships, challenging the order dated 6/6/2023, which is annexer E page 38. The case which was filed by the petitioner as informant has been withdrawn under the purview of the section 1321 CRPC by the learned court below by the additional PP, your lordships. And page 38, without considering the materials, your lordships, if your lordships kindly go to the FIR, the ingredients, the very ingredients of molestation against the informant is very much there, your lordships. Without go to the entire facts, your lordships, without going to the materials, your lordships, without recording any independent satisfaction by the learned PP, your lordships, that he has filed this application for withdrawal under the purview of this government notification dated in the past in 2022, subsequently which has been amended, your lordships, in 2024. But my case has been withdrawn in 2023, and the learned PP has without acting as on the execution executive instructions, without going to the independent satisfaction, he has filed this application, your lordships, and learned court below has failed that this case is a outcome of the cross case, your lordships, which has been pending before the learned additional district such as Rongia, lordships, registered as a POSCO against the husband of the informant, lordships. That's the very vital fact, dear lordships, which is substantially interconnected with the.
So, which is the impugn order?
Page 38, annexer F. May I read the order, your lordships? Page 38, annexer E. Accused Moon Ahmed alias Noor E. Ahmed is absent with stay by petition number so and so.
Where is the application filed by the public prosecutor?
And since I have not the annexed petition, but the things that the petition, the grounds in for which the petition has been filed, that is very much stated.
We have to see the application filed by the public prosecutor. You produce that application.
But the impugn order
Maybe.
very much clear
Even then
that
we'll verify it from the application filed by the public prosecutor. You produce it?
But that it,
Copy is available with you?
no, that is why it is very difficult for, I have not available this application, Your Lordship.
On what consideration the PP has filed the application?
On the,
And if that application is not enclosed with the record, can we consider this?
but the impugn FIR has,
No.
impugn order has stated
No,
that on the satisfaction of the notification, this application has been filed. But the thing is that this case is outcome of the cross case of the case has been pending before the additional district judge in a POSCO case, which is directly relevant to this case, Your Lordships, which is fixed on 5/8/2020 in very next week, Your Lordships. Since the FIR, Lordships, itself revealed that the allegation of molestation and charges are already been filed. I have annexed the charge sheet, Your Lordships. Whereas the investigation officer has found the materials against the respondent number 2 and 3, Your Lordships. Found him without going to the satisfaction of all the things, Your Lordships. The learned court below has allowed to withdraw the application. More so, Your Lordships, kindly see the annexure F.
No. By the notification, power is given to the public prosecutor to file the application.
Lordship. But subsequently, the annexure F, kindly see the annexure F, which has been amended.
Sorry, you produce the document.
Basis of his objection is the application of the learned. He can obtain that certified copy of that application.
No, but the thing is that I may be allowed to file an application for annexing the producing the application. But the thing is that the very connected case, which has been fixed on 5/8/2026, next week, Your Lordships. And there is a direct, this is a cross case, interconnected case, Your Lordships.
We'll see you produce the document.
Lordships, and kindly call for a record also. It will reveal
Not
everything.
today. We are not going to admit the petition today. You produce the document. Heard Mr. Borua, learned counsel for the petitioner, Mr. P. Borthakur, learned additional PP for the respondent. Mr. Borua, to a pointed query of this court, submits that he has not enclosed the petition filed by the public prosecutor before the learned trial court for withdrawing the GR case number. What is the number?
GR case number 462.
462
of
of
2018.
2018.
Connection
Before
is
the
Rongya.
court of learned judicial magistrate first class of Rongya. Accordingly, it is provided that Mr. Borua shall bring on record the application filed by the public prosecutor before the learned trial court by filing an additional affidavit. List the matter on
Lordship,
next.
may I pray for that the examination of the prosecution witness, the connected cases will fix on 5/8 till my filing of the application. That may be, Your Lordship, till filing of the application. I pray for till filing of the application.
No,
That will be stayed.
unless we are admitting the petition, we will not pass such.
But an observation may be made,
Sorry.
Your Lordship.
No. Fix a short date.
Short date.
4th of August.
4th of Lordship.
Item 20.
Based Your Lordship. Lordship, by this petition, the petitioner has sought interference of this honorable court against order dated 17/7/2026, my lord, whereby non-bailable warrant was issued against the petitioner, my lord. What has happened, my lord? Charges
Where
were
is
framed-
that order?
My lord. Page 68, my lord. The petitioner before your lordship is my lord Hazrat Ali, my lord.
So what wrong with this order?
My lord, what has happened, my lord? Charges were framed, my lord, under section 22B in the year 2019, my lord, against three accused persons, my lord. Case is still at the stage of pre-trial, my lord. Trial has not commenced yet. In the year 2022, non-bailable warrant was issued against one of the co-accused, and his appearance is still remaining, my lord. In the meantime, in the year 2025, I was regularly appearing, my lord. Either I was appearing regularly or I was being represented by my engaged counsel, my lord. In the year 2025, my lord, I went out of station with due information to my engaged counsel, my lord. I went out of station for the treatment of my daughter, my lord, at Coimbatore, my lord. All the medical documents are annexed, my lord, from page 69 to page 69 onwards, my lord. And when I returned, my lord, I tried to contact my engaged counsel, but he did not receive my phone calls. I went personally to the learned trial court below. I came to know that, my lord, non-bailable warrant is issued against me, my lord. I'm just praying for, my lord.
When for the first time non-bailable warrant of
August
arrest was issued
2025,
against
my lord.
you?
August 2025, my lord.
August 2025.
Page 57, my lord. Since 2019 to 2025, my lord, I was regularly appearing. And the medical documents of my daughter, my lord, shows that in the month of October, November 2025, I was at Coimbatore, my lord. Page 57 is the first order, my lord, whereby non-bailable warrant was issued against me, my lord. 20 August 2025.
So almost a year you remain absent.
My lord, as I was out of station, my lord.
Oh, where is the document to show that for this entire period you remain out of station?
My lord, commencing from page 69, my lord. My lord, may kindly see. 69 to 81 are the medical documents of my daughter, my lord, which shows that, my lord, from the month of November to December 2025, I was at Coimbatore. My daughter was admitted. She underwent a surgery, my lord, and she was discharged.
November to
December, my lord.
December.
December, my lord.
That's all right. But
Thereafter,
you remain absent
my
on
lord,
20
my lord.
August 2025.
My lord. Thereafter, my lord, because her condition was deteriorating since the month of August, my lord. July 2025, her condition was not good, my
Where
lord.
is that document?
My lord, those documents are not available, my
Not
lord, because
available.
the last available documents which are furnished to me, my lord, that I have annexed with my petition. Thereafter, my lord, after returning back from Coimbatore, my health condition deteriorated. Those documents also I have annexed, my lord, from page 82, my lord. This shows that since till the month of July 2026, my lord, this current month, I am undergoing treatment for myself, my lord. The last medical documents are of June to July 2026, my lord. Page 84, my lord, 85.
So
86.
this prior to 6 June 20, this is of 2025. Page number 82.
My lord. My lord, since she underwent a surgery, my lord, fluid accumulated in her abdomen, my lord, my daughter, my lord. After even after returning from Coimbatore, my lord, I had to take care of her, my lord. And I was under the impression that, as I have already intimated my engaged counsel to take steps on my behalf, so I was under the impression that I will be represented, my lord. And a couple of times, even I tried to contact my engaged counsel, my lord, but all my attempts went on vain, my lord. Finally, my lord, when phones were not connected, my lord, in the month of June 2026, I myself went to the trial court.
Better you go and file an application before the learned trial court,
My lord, I will
including all your documents, medical documents, and the trial court shall consider the same in accordance with.
Well, till then, my lord, the operation of impugned NBWA may kindly be suspended, my lord. That may kindly be done.
Yes. Heard, Mr. Your name,
P.
please?
Jain, my lord.
Learned counsel for the petition. And also heard Mr. Borthakur, learned additional PV for the state respondent. In this petition under article under section 528 of DNSS 2023, the petitioner has challenged the order dated 17/7/2026, passed by the learned session judge Kamrup M. Amingao, Kamrup at Amingao, in special and DPS case number 11 of 2019. This to be noted here that by the impugned order dated so and so, he could not. No, so and so the learned trial court has issued non-bailable warrant of arrest against the petitioner. The learned counsel for the petitioner submits that the learned trial court has first issued non-bailable warrant of arrest against him by order dated 28/8/2025, and lastly, the non-bailable warrant of arrest was issued on 17/7/2026. And according to him, during the aforesaid period, the petitioner was busy with the treatment of his daughter, and he was also out of station on account of treatment of his daughter at Coimbatore, and he was also suffering from some diseases and under medical treatment for which he could not appear before the learned trial court and also could not contract his engaged counsel, and therefore he has contended to set aside the impugned order and to allow him to remain on previous bail and also to face the trial. After hearing learned counsel for both the parties and considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner to file an application before the learned trial court, enclosing all the medical documents of his daughter and also in relation to the treatment, also the documents in relation to regarding his treatment, and on such application being filed, the learned trial court shall consider the same in accordance with law. Till then, considering the submission of learned counsel for both the parties, it is provided that the non-bailable warrant of arrest issued against the present petitioner shall not be executed. The petitioner shall appear before the learned trial court on
14th August. My lord, date is fixed on 14th August, my lord.
Okay. On 14th August.
14th August. I'm deeply obliged.
The execution of the NBW shall be kept in abeyance.
Yes. This matter has been partly heard by your lordship.
Why it was adjourned on the other day?
But if your lordship has said we'll take up on another date.
Yes.
Keeping it part of it. Yes, this is in relation to, my lord, pertaining to the dismissal of my application for amendment of the written statement. The impugned order is at page 89. The last paragraph is the operative portion. The court has given careful consideration to the facts of the case, also considered the submissions made on behalf of both sides. The death of the child, namely so and so in the custody of the petitioner, has no relevancy in determination of real question of controversy of the suit. It is a matrimonial suit for divorce of the party. As such, this court is of the view that the contention of the respondent to amend the pleadings has no merit. By this application, I wanted to bring, as one of my daughter died in the custody of my husband. The divorce suit has been filed by the husband.
No, the suit was filed
My lord.
for dissolution additional pleading for the state respondent. The learned counsel for the petitioner submits that in this case, after completion of investigation, the IO has laid charge sheet under section 4 of the POCSO Act against the present petitioner. In that view of the matter, it is provided that SSL call for the scanned copy of the record along with the case diary from the learned trial court, fixing the matter on
12 August
12 of August.
Deeply obliged, Your Lordship.
26.
This is application for regular bail, Lordship. Your Lordship, FIR dated 18/10/2024, Annexure 1, page 11. Your Lordship, in this case, I am behind the bar more than 20 months.
More than 20 months.
20 months. I was arrested on 18/10/2024, Lordship. And in this case, Your Lordship, the charge was framed on 6/6/2025. 6/6/2025, Lordship. And thereafter, till today, only one witness has been examined. Only one. Only one witness has been examined. The case record is before Your Lordship. And Your Lordship, in this case, while in the seizure, no local witness has been cited by the STF police. No local. Your Lordship will find those witnesses, though alleged seizure is alleged to be made at Chandmari near flyover in front of one physical fitness school, 10:44 p.m., where all the residences are there, shops are there, temples are there, many surroundings people are available there. But the witness
No,
side
if
case,
the witnesses refuse to become a witness
Pardon?
there, then
pardon,
if the people living in the vicinity of the place of occurrence refuse to become a witness, then
the at least the veracity is
no, veracity
right.
has to be determined at the end of the trial after examination of
Yes,
the
Lordship,
witness.
Lordship, I do. And what there has been that to impede me in this case, entrap me in this case, Your Lordship. And in the charge sheet, Your Lordship, you will find police has stated that there is no prior any criminal record against me. I am a boy of 34 years, permanent resident of Chandmari, Your Lordship, with movable and immovable property. Police has also stated in the charge sheet that he does the business of tattoo.
So what is the quantum of contraband substance?
Pardon?
What is the quantum of contraband substance?
691 gram.
Of heroin.
Heroin, Your Lordship.
So it is commercial quantity.
Yes, yes, Lordship. We may say at this stage because
So
this is a matter of weight, etc.
How you will satisfy the requirement of section 37?
Yes, Your Lordship. I am giving ruling of the Bombay High Court also that it is only for the special judge. I am giving. There are so many
Special judge?
rulings, Your Lordship.
Which is the relevant paragraph here?
26, Lordship. All the things have been discussed above, but 26. As Your Lordship has raised this issue, my conclusion is that the High Court power to release the accused suspected of having committed an offence under the Anti-Theft Act is not limited by Section 439 of the Code of Criminal Procedure. The summary of the reasons for this conclusion The court referred to in section 37 of the NDPS Act being a legislative substitute for the magistrate of the first class occurring in the repealed section 36 is not intended to include the High Court. Secondly, the Parliament has identified the special court with the court of the magistrate whose power to grant bail is restricted under section 437 of the CPC. CRPC. The restriction of the power of release on bail created by section 37 of the NDPS Act being similar to that under section 437 of the Code of Criminal Procedure. The Parliament did not intend to include High Court within the words special court. Thirdly, section 37(2) of the NDPS Act has conceived the limitations on granting bail specified in section 37(1)(b) as in addition to the limitation under the Code of Criminal Procedure. Therefore, in the Parliament's conception, the court is a court whose power to grant bail is limited by the Code of Criminal Procedure. The High Court, not being a court of such restricted power to grant bail, is not the court conceived by section 37 of the NDPS Act. Fourthly, the construction of the words the court used in section 37 of the NDPS Act deprives the power court of its establishment jurisdiction. There are no words in the NDPS Act which bring out the intention to take away the jurisdiction of the High Court under section 439 of the Code of Criminal Procedure. Order. For the reasons above, the applicant is allowed this. And
So how this observation will help you?
this court can grant me bail. And second, your
No,
your
there is
lordship
no
also
doubt
the-
about it. This court has
also
the power to grant you bail.
Yes.
But how do you satisfy the requirement of section 37?
No, regarding 37, just I have read out that
Yes.
the High Court is not restricted by that. That is only for the trial and the special judge. Because 439 has given the special power to the High Court. And moreover, section 36 A3 can be also produced of the NDPS Act. Lordship.
So your contention is that this court has not to consider section 37 of the NDPS Act.
Yes, so far bail is concerned, your lordship, this court has got power to grant the bail.
No, there is no doubt about it. This court has the power.
And your lordship.
The question is whether this court will consider section 37 or not.
That is, will consider, your lordship.
This court has to consider.
Your lordship, in the bail matter, there is no restriction to grant bail by this honorable High Court.
No, that's all right.
And
now my question is, if this court has to consider section 37, then how do you satisfy the requirement?
No, not to consider, not to follow this stringent provision.
Or not to
It
follow?
is only to be considered by the special court while in trial, because it has been made clear. And another, your lordship, under the same act, 36A of the NDPS Act, I am reading out subsection 3. Subsection 3. 36A, subsection 3. Section 36A, subsection 3, lordship. Nothing contained in this section shall be deemed to affect the special powers of the High Court regarding bail, and under section 439 of the Code of Criminal Procedure 1973, and the High Court may exercise such powers, including the powers under clause B of subsection 1 of the section, as if the reference to magistrate in the section included also a reference to a special court constituted under section 36. So this court has got power to grant bail under this NDPS Act. And second aspect, Your Lordship, will find that in this case, charge was 11 numbers of witnesses. Charge was framed on 6/6/2025. And only one witness has been examined so far, Your Lordship. And more than 20 months he is in jail. There is no question of any tampering, etc., influencing any person. All are official persons, Your Lordship. So my respectful submission, he is a 34 years boy. His life can be saved by imposing any condition, Your Lordship. By imposing any condition, Your Lordship.
Okay, yes.
My lord, in this case, though my lord, 10 picture was confirmed, but from the trial court, my lord, original case record was come, my lord.
Yes.
That is my lord, I have, my lord, just pointed out the your lord, my lord. My lord, I have come to the same, my lord. Here, my lord, as on today, my lord, that is, there's a 1 year, 9 months and 13 days. That is, my lord, 21 months and 13 days. And my lord,
20?
That is, my lord, the period of the arrest is, my lord, as of
21 months?
But 1 year, 9 months and 13 days, my lord, 1 3.
Almost 20 months, 18, 10,
21 months and 13 days, my lord.
Okay.
Yes, my lord.
Okay.
And my lord, regarding my lord, this implication, my lord, contraband from the vehicle, my lord. My lord, that is my lord recovered, and it was my lord, and the my lord, that is the footrest of the vehicle, my lord. 2 persons are there, my lord. This person along with another, my lord. So, my lord, from the conscious position, my lord, that is my lord.
No.
Procured, my lord. That is from the there. I have my lord flag mark, my lord. That is the my lord complainant, my lord informant, my lord. His my lord statement, my lord, clearly, my lord, reflect all the things, my lord. Now, my lord, Caesar witnesses, my lord, 2 numbers of Caesar witnesses are there. They were not examined as per the record, my lord. PW was examined on my lord 19/12/2025, my lord. 19/12/2025, my lord. And my lord, the CS submitted on my lord 10/4/2025. 13 numbers of PWs are there, my lord.
13.
And my lord, charges frame on my lord 6/6/2025.
1 year gone. More than 1 year.
2025, my lord. Otherwise, my lord, Caesar witness not examined, my lord.
No. Now the question is whether section
Your Lordship,
37.
one thing, Your Lordship, from the 19/12/25 bail order, Your Lordship will find that the scooter belongs to brother of the, that is order is there. That the vehicle was of one Tapan Deka, brother of one co-accused Manoj Deka. I know here, Lordship, and nothing from my physical position, not even a single paisa, nothing of the sort, Your Lordship. One scooty foot mat in one bag, it is alleged that 691 grams of the heroin was there. That scooter belonged to, that order is bail order, that is reflected there in the very beginning by the learned special judge. I am nowhere,
Okay,
Your
okay.
Lordship.
Now the question is whether this court has to consider section 37 or not.
My lord, as per my guidance, your colleague's submission, my lord, that my lord, he is on the tracing that my lord prolonged incarceration, my lord. Till that only my lord, one PW, one is my lord examined, my lord. Because of that, my lord, rigor of 37 will not apply, my lord. My lord, in this case, my lord, the commercial quantity, my lord, which is my lord, applied, my lord, by the police, my lord. And my lord, otherwise, all my lord things are complied, my lord, and my lord, Caesar witness is not examined, my lord. In this case, my lord, if it is my lord, allowed, my lord, he is allowed on bail, my lord, it will affect the my lord, the trial.
Lordship, trial has started. I don't know whether the Caesar witness has been examined or not.
Okay.
Trial has started.
Okay, we'll pass the order.
Obliged, Your Lordship. Murna.
Number 49.
Wait, please, Lordship.
Yes.
Lordship was supposed to hear the matter with regard to the issue of maintainability. Lordship, maintainability vis-a-vis the judgment passed by the Honorable Supreme Court. Lordship. Now, I have gone through the judgment, Lordship. Lordship, in that judgment, the provisions of law pertaining to the PMLA Act was challenged. Different provisions of law. And all those provisions of law were upheld by the Supreme Court. But that is a very different aspect of the matter. And what I have filed a writ petition, I have not challenged any provision of law. And I am in consonance with the Honorable Supreme Court, what the Honorable Supreme Court has said. So, Lordship, my question is entirely different. Now, my learned friend, he has an objection with regard to maintainability and on the ground of premature. What I can basically understand, Lordship, as per the Act, because I will go as per the Act because, Lordship, the Honorable Supreme Court has upheld the Act in total. Now, Lordship, with regard to that section 17, Lordship, once an authorization is granted by a director or to any other authorized person, the director or any other authorized person can go and conduct the search and seizure, Lordship. There is no problem in that. Now, when it comes to with regard to any bank account, the bank account can also be seized, Lordship. There is also no problem in that, Lordship. But, Lordship, my case is that after seizing, Lordship, and during the time of seizing, there has to be reasons recorded in writing. That is my case. Now, Lordship, for that, Lordship, Lordship, I would like your Lordship to kindly peruse there are two. One is section 17 of the Act and rules frame of 2005, Lordship. And Lordship, before going into that aspect, Lordship, I would just, Lordship, I would like to just place what is the facts of my case. Lordship, may kindly take up my writ petition once, Lordship.
Yes.
Lordship, I have already referred to the Panchnama.
Yes.
Number 31.
Yes.
The only thing that I would like to highlight is that the person who have conducted the search was given an authorization number by the deputy director under subsection 1 and subsection 1A. However, no authorization has been displayed, has been given to me, or a copy of the authorization. What is written in the authorization? Nothing has been given to me. Now, what they have shown me was a search warrant. In page number 32, there is a search warrant. The third line, Lordship. We have explained the contents of the said search warrant. So now authorization is different and search warrant is different. I'm just pointing out, Lordship, and I'll come to why I'm saying so, Lordship. Now, total Panchnama is of 8 pages, Lordship. And after that, Lordship, the freezing order. In the freezing order, which was passed under section 17(1)(a) of the PMLA Act, it was a very mechanical order. Only thing they have stated is the bank accounts and nothing else. And the subsequently at page number 40, may I just read the last part?
Yes.
I further order that the funds lying in the aforesaid account to the extent of the balance mentioned above shall not be transferred or otherwise dealt with, and complete bar on operation related to his account, except with the prior permission of this office of the Deputy Director, Gauhati Zonal so and so, full stop, which shall result in the frustration of the proceeds of crime or hamper the investigation under the Money Laundering Act. So he himself has stated that you can open it if we allow you to do so. Now this comes from the Act itself. Lordship, may kindly see the Act. The PMLA Act, Lordship, Section 17.
Yes.
17(1)(a), where it is not practicable to seize such property or record or property, the officer authorized under subsection 1 may make an order to freeze such property, whereupon the property shall not be transferred or otherwise dealt with, except with the prior permission of the office making such order, and a copy of such order shall be served on the person concerned. Now, Lordship, this is quite clear that we will be able to operate the account if permission is granted by the authority. Now, because of this provision, I have already made an application.
You are referring to
Section 17(1)(a).
A.
Yes, Lordship. That permits me to operate it with the permission of the officers concerned.
Which part you were reading?
Lordship, Section 17.
1A.
1A.
Yes. Read it again.
Where it is not practicable to seize such record or property, the officer authorized under subsection 1 may make an order to freeze such property, whereupon the property shall not be transferred or otherwise dealt with, except with the prior permission of the officer making such order, and a copy of such order shall be served on the person concerned. So this is allowed. Now, because of this section, Lordship, I have filed a representation, Lordship. Lordship may turn to page number 41. Sorry, Lordship, this is 41 is a representation to the bank, Lordship. I'll skip that, Lordship. 42. Deputy Director, Lordship. On 13/7, I have made this representation to the Deputy Director. Lordship, neither here nor in the writ petition, I have challenged the search and seizure. I have only said that you have seized a lot of items. I'm not concerned, but you have seized the company's account, frozen the company's account. Kindly let me operate it, and I will cooperate with you in whatever form I want, because if you do not let me operate that account, I will not be able to do my business. Everything will be stopped. I'm a government contractor. Government work will also be stopped. That is what my contention was, and that is my contention before this honorable court also, Lordship. Now, Lordship, if sees my prayer in page number 43, I have mentioned everything, Lordship. I may just read from page number 42. So my company is not involved in any money laundering activities, and your departmental officer has seized things only on suspicion. The company has its legitimate GST number, registration with the Companies Act, and all documents required to do business which the company is undertaking. The account which is freezed is the current account of the company, which is a business account, and the company is having 18 numbers of employees. Due to freezing of the account, we are unable to pay the salary to the employees, make payment to the rice suppliers from whom we have purchased on credit and also pending EPFO contributions. Moreover, due to freezing of the account, we are unable to carry our business. At the time of freezing, no explanation was also sought for from the company regarding the amount lying in the aforesaid account. The money in the account of the company is legitimate and are not proceeds of any crime, and the same can be easily explained. However, on such exercise was carried out by your departmental officers while conducting the no such exercise was carried out by your departmental officers while conducting the raid. As such, I beg to you to kindly defreeze the account so that I can continue with our business, which is our fundamental right. I also undertake that I will abide by any such conditions imposed by you for your cooperation of your inquiry, especially when the other seized items are already with you. If you direct defreezing of the company's account, number so and so. And I have also served a copy to the one who has attached, the one who has given the freezing order, copy to Mr. Basab Bhattacharya, Assistant Director. So these applications were already filed before them, but they have not considered this application. Now, this is the mandate of law. Section 17 grants me the permission to use it with prior permission from them. So I have asked for permission, they have denied it. Now, my writ petition is in a very different context. And what the Honorable Supreme Court in the 3 judges bench did was a different aspect altogether. And I abide by whatever the Supreme Court has said, Lordship. And Lordship, one more thing, Lordship. In similar circumstances, recently, Lordship, no, if not similar, Lordship, with the prayer is the same, Lordship, for defreezing of the account. I would like to rely on judgment order passed by the Kolkata High Court last week, Lordship. It is with regard to All India Trinamool Congress, where ED have they have frozen every account of all the MLAs, Lordship. Now, in that case, Lordship, I am relying in this case only not with regard to the facts of the case. Facts will be always different. All I am relying on is the principle of law with regard to maintainability. Now, today's question was with regard to maintainability of my writ petition. So, Lordship, in this case, the full bench judgment of the Supreme Court was relied on. And then, Lordship, the Honorable Kolkata High Court has come to a categorical finding that writ petitions are maintainable against the freezing orders. And it will depend on each and every merit of the case. It is different from each other. My facts of the case and the case of the Trinamool Congress will be obviously different. But the maintainability of a writ petition challenging the freezing order, while there being provisions of Section 17, is maintainable. Now, as I could understood, my learned friend is of the view that because Section 17 provides for the authorized officer to make an application within 30 days to the adjudicating officer in Delhi, saying that I have frozen this account and these are my reasons in writing. That is why it is not the mandate to write his reasons at the time of the search. That is what I believe may be the stand of the opposite party. But that is where I am relying on also a Supreme Court judgment in this gray area. Also, I'll just refer to the first. I'll just read what was the finding, what was the submission, a short submission, and the finding of the Kolkata High Court, Lordship. Lordship may kindly take up para number 12, where the Kolkata High Court was intimated about the Vijay Madan Chaudhary case, Lordship. This was passed on very recently, Lordship,
Mm.
on 27 of this month, Lordship.
Okay, paragraph number 12.
12.
Hmm.
Mr. Singhvi had relied upon the judgment in the case of Vijay Madan Chaudhary and others versus Union of India reported in 2023 12 SCC 1 and submits that the possession of unaccounted property acquired by legal means may be actionable for tax violation and yet will not be regarded as proceeds of crime unless the tax legislation concerned prescribes such violation and as an offense, and such offense is included in the schedule of PMLA 2002. So this, Lordship, I would refer to the paragraph which it is there in the Supreme Court judgment. Lordship may kindly note paragraph number 106 of the Supreme Court judgment. This has been described. What is a crime proceed or a proceeds of crime as per the PMLA?
Paragraph number
106, Lordship. May I just read what is the proceeds of crime? Lordship, got it?
Got it.
The proceeds of crime being the core of the ingredients constituting the offense of money laundering, that expression need to be construed strictly. In that, all properties recovered or attached by the investigating agency in connection with the criminal activity relating to a scheduled offense under the general law cannot be regarded as proceeds of crime. There may be cases where property involved in the commission of scheduled offenses attached by the investigating agency dealing with that offense cannot be wholly or partly regarded as proceeds of crime within the meaning of section 21U of the 2002 Act, as long as the whole or some portion of the property has been derived or obtained by any person as a result of criminal activities relating to the stated scheduled offense. Not any other offense, Lordship. It has to be from the scheduled offense of the PMLA. Now, reading further, Lordship, to be proceeds of crime, therefore, the property must be derived or obtained directly or indirectly as a result of criminal activities relating to the scheduled offense. To put it differently, the vehicle used in commission of the scheduled offense may be attached as property in the case crime concerned. It may still not be proceeds of crime within the meaning of section 121U of the 2002 Act. Similarly, the possession of unaccounted properties acquired by legal means may be actionable for tax violation and yet will not be regarded as proceeds of crime unless the tax legislation concerned prescribes such violation as an offense, and such offense is included in the schedule to 2002 Act. For being regarded as proceeds of crime, the property associated with the scheduled offense must have been derived or obtained by a person as a result of criminal activity relating to the scheduled offense concerned. This distinction must be borne in mind while reckoning any property referred to in the scheduled offense as proceeds of crime for the purpose of the 2002 Act. Dealing with the proceeds of crime by way of any process or activity constitute offenses of money laundering under section 3 of the PML. Now, it has to be first established that whether the proceeds of the crime has been derived from the offenses as described in the schedule of the PMLA. Now, how do we ascertain that, Lordship? To ascertain that, Lordship, it is the respondents who has to say, or there has to be a specific question made to me. Section 17 is a presumption, an assumption that there may be proceeds of crime with me and there may not be. Now, Lordship, I'm just the last portion, how I say that this writ petition is maintainable, because in the Kolkata High Court, I have also challenged the freezing order and they have also challenged the freezing order. My contentions are different, their contentions are different. And now at the last portion, in this case, I fairly submit the interim order was rejected. But maintainability of the writ petition was allowed, Lordship. And this is how it goes, Lordship. I'll just place it. Page number 24, pair number 36.
No, whether the freezing of the bank account of the Trinamool Congress
Yes.
was in relation to money laundering act?
Yes. Enforcement Directorate, Lordship, ED, Lordship.
It is always money laundering, madam. In the PLMA is
Always money laundering.
only money laundering. We look into money laundering case only.
Okay.
PLMA. Prevention of Money Laundering Act, madam.
No. My query is whether the bank account of the Trinamool Congress was seized or freezed under the PMLA Act or not?
Yes, Lordship.
PMLA Act.
Lordship. Okay. Lordship, I'll just read it, then Lordship will know. I mean, what is the difference? How? Lordship, only when it is for them to answer it. It is not for us to say it. Lordship, I'll just read it, Lordship. Kindly read pair number 36 once, Lordship. As regard to the alternate remedy, the respondents has filed a writ petition challenging the very initiation of ECIR proceedings by the ED. It is a specific case of the petitioners that the alleged transactions were neither sudden nor emergent in nature, so as to initiate invocation of the extraordinary powers contemplated under Section 17 of the PMLA Act 2002 at the stage where the legality of the freezing of the same account is pending consideration. Same case here, Lordship. It is well settled law that there is no absolute bar in filing the writ application if any alternate remedy is available. The petitioners have raised the issue of arbitrariness of the respondent authorities at the proceeding as it was initiated without any jurisdiction. The same is to be denied only after exchange of affidavits. Now, my contention is that there is no sale proceed. You are not doing this. Section 17 is not complied with this. That is my allegations or my contentions for filing the writ petition. Now, that has to be answered by a way of affidavit. Only then Lordship can go into the legality whether whatever submissions I'm making it is correct or not. But prima facie, do I not have prima facie? Is this writ petition not maintainable? And I do not believe that that is a remedy available to me. My remedy was before the Section 17(2)(1)(a), which was denied to me. I could have opened the account if they would have allowed me to. I need not go to the authorized adjudicating authority there. He had this power. Section 17(1)(a) gives the power of to the deputy director or any authorized officer of the ED to open my account. Only they have to be satisfied that the amount which is in my account are crime proceeds or not. They can very well ask for explanation to me. They have done the searches. They can very well take my statement to that effect. Now, Lordship, again, the ED, after analyzing the bank accounts of the petitioner number 1, finds that substantial transfer of funds to various entities, most predominant out of them is one Carewell Group, was transferred from the said account. The ED has not debit freeze the other 36 accounts of the petitioner number 1, in which amount of rupees 164 crores were lying. So they did not freeze all accounts. They only froze one account. But in this case, I have already shown you, Lordship, the blanket order. Whatever account I have, all are seized. I'm a director of a company, that company's accounts are also seized. Now, in this case, the ED has done a right thing. Seized only the account where sale proceeds, crime proceeds may be there. This court did not find any prima facie case and balance of convenience or inconvenience in favor of the petitioners. In view of the above, the interim order as prayed by the petitioner is refused. That I fairly accept that interim order was refused. That is, I'm not on that, Lordship. Again, the respondents are directed to file affidavit in opposition within 3 weeks. Reply, if any, within 2 weeks thereafter. List the matter on 26th August 2026. It is upcoming, Lordship. Now, it is quite clear that this writ petition is maintainable. I may not have a good case on merit, that is a different aspect, Lordship. But filing of the writ petition, challenging the freezing order is maintainable, Lordship. Now, one last aspect, Lordship. Lordship, with regard to section 17, my categorical statement is, my submissions are that under section 17, the deputy director authorizes an assistant director to go and conduct the search. He goes and conducts the search. He freezes my account. He comes back, and after 30 days, he writes his reasons in writing to the authority, adjudicating authority. That may be not correct, because the Honorable Supreme Court, in a recent judgment of 2021, has categorically stated that for the purpose of section 17, it may be the director, deputy director, authorized officer, assistant director, doesn't matter. The law says you have to record reasons in writing, and at the time of search also, you have to record your statements in writing as to why do you think these are crime proceeds. Reasons recorded in writing has to be there. Now, I'll refer to that judgment now. Lordship. The three judges benches of the Honorable Supreme Court has not dealt this point, Lordship.
Yes, paragraph number
9, Lordship.
Yes.
A perusal of the above provisions would indicate that the prerequisite is that the director or any such authorized officer, in order to exercise power under section 17 of the PMLA, should, on the basis of information in his possession, have reasons to believe that such person have committed act relating to money laundering, and there is the need to seize any property, record or property found in the search. Such belief of the said officer should be recorded in writing. Subsection 1A of section 17 of the PMLA provides that the authorized officer under subsection 1 may make an order to freeze such record or property where it is not practicable to seize such record or property. Subsection 2 provides that after search and seizure and upon issuance of a freezing order, the authorized officer shall forward a report of the reasons recorded along with his materials in his possession to the adjudicating authority in a sealed envelope. That is a different exercise. We are not concerned now, Lordship. Subsection 4 provides that authorized authority seizing or freezing any record or property under subsection 1 or 1A shall, within a period of 30 days from such seizure or freezing, as the case may be, file an application before the adjudicating authority requesting for retention of such record or property seized, as I was submitting on the last occasion, Lordship. So, for the purpose of the Act, recording reasons for any purpose, maybe for seizing or for freezing, recording in writing is a must. That is not what I said, Lordship. This is the interpretation of the Honorable Supreme Court, Lordship. So, my humble submission is that this writ petition is maintainable. Let them file their reply.
Okay.
Affidavit in opposition, then we will.
Yes.
Matter is very premature. Why I will just consider this honorable court for the law. My lord, the PLM. My lord, first I will just come to page number 39 of the writ petition. It is the, my lord, freezing order under section 17(1). My lord will find order of freezing under section 17(1)(a) of PLM. So by this order, my lord, 7 numbers of bank account have been freezed. And the next page, it says, page 40, I further order that funds lying in the above account of the extent of the balance of mentioned above shall not be transferred or otherwise dealt with and complete bar on operation related to this account. Meaning thereby, my lord, we have freezed it. Now, whether we have the power to freeze it, my lord, what the PLM says. My lord, again, I will read, my lord has PLMA Act, my lord. 17(1)(a), my lord. Where it is not practicable to seize or record or property, such recorded property. Why this is, my lord? Because the bank account, my lord, this is neither we can carry it somewhere and we can lock it. My lord, bank account is a digital account, my lord. So we have to buy an order to freeze it. Whether it is not practicable to seize such record or property, the officer authorized under subsection 1 may make an order to freeze such property, whereupon the property shall not be transferred or otherwise dealt with, except with the prior permission of the officer making such order. And a copy of such order shall be served on the person. My lord, the sentence doesn't stop here, my lord. It continues. My friend has just cut short it here. Now, my lord, it follows. Concerned. There is a hyphen. Then it says, provided that, the next parameter, provided that if at any time before the constitution under section 5 or subsection 7 or subsection 8, these are not subsection 8 is, my lord, the proceeding before the adjudicating authority, my lord. If it is before subsection 8 or section 58B, these are all proceedings. Or subsection 2A or section 60, it becomes practical to seize a frozen property. So, my lord, this is with regard to those frozen property. Now comes this, what my friend is harping upon, reason to believe. How to write a reason to believe and whom to write. This comes in number 2. The authority who has been authorized under subsection 1 shall immediately, my lord, immediately, it is not 30 days, it is immediately after search and seizure or upon issuance of freezing order, forward a copy of the reason, that is, my lord, reason to believe. Reason so recorded along with material in possession referred to in that subsection to the adjudicating authority in a sealed envelope. Not to him, my lord, it will go to before the adjudicating authority who is authorized under subsection 8 of the PLMA Act. Sealed envelope in the manner as may be prescribed, and as such adjudicating authority shall keep such reasons and materials for such period as may be prescribed. So, my lord, we have done it. That is the thing. Immediately after issuing the order, my lord, we have sent it. On 9 July, my lord, reason to believe it is all done. And, my lord, from 3rd, it is, this 3rd is 30 days. Already our original application, OA, my lord, we have placed it before the adjudicating authority in Delhi. Maybe it will get registered tomorrow. Now, my lord, I will just cut short, my lord. I will take the code, my lord, this act, my lord, Vijay Madan Lal. Now, my lord, will come to 187. This is what, my lord, very nicely, the entire act has been, my lord, incorporated here in this order. Honorable Supreme Court order, my lord, and how it is dealt with, and how it is being done, my lord. Everything, my lord, Supreme Court has laid down. How we should proceed. It is there. So, my lord, basically 187, that is search and seizure, that act is my lord, compiled here. It is reproduced. Then, my lord, in next 209 page, that is just I read that regarding reason to believe. How we will send it, it is there. Then, my lord, will come to page number 210. It is 4. 17:1:4, my lord. The authority seizing any record or property under subsection or freezing any record or property under subsection 1A shall within a period of 30 days. My lord will mark it is 30 days. 30 days from start, freezer or freezing. Freezing as the case may be. File an application requesting for retention. My lord, it is 30 days is for retention, further retention. Requesting for retention of such record or property freezed under subsection 1, which is already, my lord, we have freeze. That we will file an application within a period of 30 days before the executing authority under subsection 8, my lord, for further retention. That is 30 days, my lord. First, it says, my lord, we should communicate immediately. We have communicated, and now it is thereafter 30 days. It is in the act. That is what, my lord, Honorable Supreme Court has just, my lord, has here incorporated. Now, my lord, 193 I am reading. 193 of this para 193.
Yes.
As aforesaid, section 17 provides for inbuilt safeguard. My lord, section 17 is such an act, section, my lord, it has given safeguard to both the parties, to the petitioner as well as us. Inbuilt safeguard, not only mandating exercise of power by high-ranking officials or rank of the rank of director or deputy director authorized by the director in that regard, but also to adhere to other stipulation of recording of reasons regarding the belief formed on the basis of information in possession and commission of offense of money laundering and possession of proceeds of crime involving in the money laundering. Further, such recorded reasons along with materials are required to be forwarded to the 3-member adjudicating authority, my lord. My lord, it is not a one person, it is 3-member, 3 judges. 3-member adjudicating authority appointed under subsection 6 of the 2002 Act, headed by a person qualified for appointing as district judge in a sealed cover to be preserved for a specific period, thus guaranteeing fairness, transparency, and accountability regarding the entire process of search and seizure. My lord, clear meaning thereby, if ED by an authorized officer goes in, does a search and seizure, passes any order, my lord, freezing order, he has to, my lord, immediately after, my lord, issuing that order, has to communicate all things, whatever he is in the position, in a sealed envelope to this authority. Thereupon, my lord, what happens next? 195, my lord, that I'm reading, my lord. 195. The process of search and seizure under 2002 Act is therefore not only for the purpose of inquiring into offences of money laundering, but also for the purpose of preventing money laundering. This is markedly distinct from the process of investigating into a scheduled offence. My lord, why the legislature in its own wisdom has come up with this section, my lord? It is, my lord, only a stopgap arrangement, and my lord, a neutral body has been set up with a quorum of 3 judges, my lord, who will look into it, my lord. Now they will get notice. You come and whatever you have to say, you say it here before them, my lord. They will get notice. Now, my lord, 198. As noticed earlier, in terms of section 17(2) of the 2002 Act, immediately after the search and seizure, the authority conducting the search is obliged to forward a copy of the reasons recorded and materials in his possession to the adjudicating authority in a sealed envelope. The sealed envelope is required to be preserved for a period of as specified under rules framed in that regard, so that it is not tampered with in any manner and to ensure fairness of the procedure, including accountability of the authority. Not only that, in terms of section 74 of the Act, the authority seizing the record of property is authorized to submit an application before the executing authority within a period of 30 days. Therefrom, on the retention of said record, and the executing authority in turn gives opportunity to be heard. Now, my lord, the next procedure. Authority in turn gives opportunity to be heard by issuing focus notice to the person concerned before passing order of detention of records or property, as the case may be, under the 2002 Act and the rules and thereon. The authorities carrying out certain seizure are also made accountable by providing for punishment under section 62 of the Act for vexatious search and giving false information. All this inbuilt safeguard prevent arbitrary exercise of or misuse of power by the authorities appointed under the Act. So, my lord, here suppose the authority, ED, has done something wrong. My lord, they can be prosecuted. That is what Supreme Court says. It is not that, my lord, it's a self-contained, that is what in 200, para 200, my lord, suffix, it is observed that the power of search and seizure entrusted to the authorities under section 17 of the Act is a special self-contained provision and is different from the general provision of 1973 Code, which therefore ought to prevail in terms of section 71 of the Act, my lord. So, my lord, so that is what Supreme Court says, my lord. It's a self-contained thing. And how it will go forward, my lord? We have just, my lord, passed a freezing order. We have immediately communicated before the authority. Now, within 30 days time frame, we have to file our, my lord, that's expiring on 3rd August. Within this time, my lord, we have to file our application. They get a show cause notice. If the, my lord, that is a court, my lord. That is, executive authority is a neutral body, 3 judges forum, my lord. They will look into it. We have to go and argue our case. They will go and argue their case, my lord. If they find it, yes, we have done something wrong, my lord, they will just release the thing. That is the Act goes, how it is done. And suppose, my lord, under section 8, there, my lord, they find it that, yes, whatever ED has apprehended, it is correct. They pass an order. They will then go to appellate tribunal. Then, my lord, under section 42 of the Act, they will come before a division bench in an appeal. This is the forum, my lord. Why I am telling, my lord? Such cases keeps coming. Our, my lord, other benches have passed few orders, my lord. I have order, my lord, here. I'm just placing it with your lordship. We said that it is not maintainable, my lord. They said on Article 20. So, my lord, ultimately they said go before this authority and fight your case there. My lord, this is the case. This is about, we already proceed and notice was issued by the authority, my lord, under section 8. This is, that was on the second step. Here he is very initially here. Here, my lord, already authority under section 8, my lord, has passed a show cause notice. That is what was challenged, my lord. Still the court said it is not maintainable and they have to go. It was what, my lord? I am just reading from page number 9, my lord, para 14. On a bare reading of section 8 of the PLMA Act. My lord, section 8 is the, my lord, that is executing authority, my lord, show cause notice, my lord. The second speech, my lord. On a bare reading of section 8 of the PLMA Act, more particularly subsection 1, it is clearly that executing authority is empowered to issue show cause notice.
Mr. Dhar, this is a from page number 5. This is a copy of the rate petition. Do you have another copy?
Maybe by default to get. Sorry, just draft means.
Okay.
I can just left hand side, my lord will not take into account.
You give the case number to him.
Case number is writ petition 7331 of 17. 7331 of 17. Order dated 31/25.
Yes.
Para 14 minutes. That is page 9 minute. This is the case was filed challenging that suppose not invalid section 8. The next page. Once we have filed our that within 30 days we have filed our OA minor, then suppose not invalid issued under section 8. That was still invalid. Only there reading of section 8 of the PLMA 2002 more better subsection 1. It is there that no authority is about to issue suppose notice on a receipt of complaint under section 5 of PLMA 2002 and also under section 17(4). Of 17(4 ballot we have already communicated. PLMA 2002 and 1810 of the PLMA. Under subsection 2 of the 8, section 8, if duty is cast upon the executive authority to consider the reply by the notice and to hear the aggrieved person as well as investigating authority and to pass an independent order taking into account all relevant materials placed on record before it. Thus, there is no iota of doubt that executive authority being empowered to adjudicate the rights of the parties. Such authority, while deciding the right of the parties, must apply its independent mind and to arrive its conclusion and cannot solely replicate or rely on the reasons given by the investigating authority as much as it is entrusted with adjudication. And adjudicating authority which adjudicates right of the parties must be fair and neutral. The adjudicating authority under PLMA cannot be a mouth of speech of enforcement directorate. In Vijay Madan Lal Supra, while dealing with section 8 of the PLMA Act, the Honorable Court held that adjudicating authority while exercising the power under section 8 of the PLMA Act 2002 may disagree with the investigating authority. In the case in hand, there is though it is seen that the provisional attachment property is immediately under the judicial custody at the time of provisional attachment, and it is argued that the backdrop of such, my lord, this is a little different. It is already there. Now I am reading 18, my lord. So, my lord, basically here what the court is, my lord, is my lord speaking, my lord, the word is following that executing authority is the my lord independent body. They will apply their own mind. That is the Act says, and that is what Supreme Court has held. It is not an authority where ED will go and say something and they will just pass an order. No, my lord. Executive authority is an independent body. They will apply their own mind and they will pass an order, my lord. Now, my lord, para 18. The right of the petitioner to reply to a show cause notice is available right under the scheme of PLMA 2002. The petitioner shall have a reasonable opportunity of hearing such hearing before the adjudicating authority under the scheme of section 8. As much as in the event the petitioner can convince and satisfy the adjudicating authority as regards not having any basis of proceed with the complaint filed under section 5 of the act. The adjudicating authority can pass an order in favor of the petitioner under section 8(2)(c) of the act. It is also noteworthy to record that the petitioner shall have further right under section 26 of PLMA 2002 against any order that may be passed by the adjudicating authority, and he will have further right under section 42 of the PLMA 2002 to approach the High Court having jurisdiction against the order in the appellate authority. So, my lord, basically here, why I was telling premature, my lord, because my lord, by an act already the statute has already formed a authority, my lord, that is adjudicating authority under section 8, where it will proceed. Because they are the expert body, my lord. They will look into it, my lord, whatever it is. Because it will go either way. They are a neutral body. We have just submitted, they will get a show cause notice. My lord, they may say, no, this is what it is, what you have done, it is wrong. They will differ with it. End of it, my lord. And if suppose they say that we are correct, they will have a chance of appeal before the appellate authority, then my lord, in the High Court, then they can always go to Supreme Court. That is always there. But my lord, this is premature. So my lord, that in this line, my lord, this was dismissed. Now, my lord, whether Supreme Court has time and against it, when there is an under the act, there is an alternative remedy under a statute, my lord. A writ petition should not be, my lord, entertained, my lord. That is what, my lord, I have a case, 2010 4 SCC 772, my lord. 2010 4 SCC 772, Rajkumar Shivare versus Assistant Director, Directorate of Enforcement. But I will just.
No, in one of the case, Supreme Court has carved out some exception also.
No, my lord, I will come to that. I will come to that. That exception, my lord, that is the altogether different issue, my lord.
Here, which paragraph you are relying upon?
My lord, para 34.
32. Yes.
Para 34, my lord. When a statutory forum is created, so my lord, a forum is created by an act. My lord, that is section 8, section 6, and now section 8. When a statutory forum is created by law for redressal of grievances and to that too in a fiscal statute. So my lord, PLMA, it's a fiscal statute, my lord. Statute, a writ petition should not be entertained ignoring the statutory dispensation. In this case, the High Court is a statutory forum. My lord, here they should have come. They have come in a writ. They should have come in a this judicial this appeal. My lord. It should have been a writ appeal. They have come in a writ petition. That is what the Supreme Court has held. My lord. Statutory forum. In this case, High Court is a statutory forum of appeal on question of law. That should not be abdicated and given a go by litigant for invoking the forum of judicial review of High Court under writ jurisdiction. So, my lord, in a writ jurisdiction, when there is a forum, my lord, you just cannot come in. That is what my lord Supreme Court has laid down. The High Court, with great respect, fell into the manifest error by not appreciating the aspect there of the matter. It is, however, dismissed the writ petition on the ground of lack of territorial jurisdiction. High Court is dismissed, but Supreme Court said, when there is a, my lord, forum under a statute, my lord, writ should not be entertained. Now, my lord, I'm reading para 36. Reference may be made to the Constitution Bench decision of this court rendering in such and such of Dhubri reported in AIR such and such, which was also this is what the court said next para. The High Court does not therefore act as the court of appeal against the decision of the court of tribunal to correct errors of fact and does not assume jurisdiction under Article 226 trench upon the alternative remedy provided by the statute for obtaining relief. So, my lord, when there is an alternative remedy under the statute, my lord, usually High Court should not. That is what Supreme Court take, my lord. Now, my lord, why I was telling this premature? Already, my lord, we have communicated. So 17.4 we have invoked. Now, my lord, 17.4 is invoked. Now, my lord, there will be two parallel proceedings. My lord is taking up one matter here in a writ jurisdiction, and my lord, in Delhi again, my lord, another my lord. So, my lord, whether two parallel proceedings for the same matter, my lord. Freezing order, my lord. Because freezing order we have already communicated. Freezing order, my lord. Already we have communicated. We have freezed. Now it is before the authority we have communicated. Now, my lord, whether when there is already, my lord, before they file this writ petition, it is gone. So, my lord, whether now, why I say, my lord, this premature. This court will have, my lord, a jurisdiction. When, my lord, if writ appeal, my lord, this tribunal also passes an order against either of the party, then only it will come before the High Court. But at this moment, my lord, this is premature, my lord. Because already we have invoked 17.4. That is what Supreme Court said. Oh, my lord, after telling this section 17. Just that I read.
Okay, okay. But whether his fundamental right is not violated by seizing all the bank accounts, by freezing all the bank accounts?
No, my lord. Fundamental right is not violated, my lord. How can be fundamental? If there are proceedings of crime, that is he has to answer, not here, my lord. Before the authority, my lord, because we are the expert body under the statute, because, my lord, whether there is proceedings of crime, my lord, because reason to believe already written, they will be examined, my lord. Because reason to believe, my lord, will not be examined before a writ jurisdiction. It will be examined before, my lord, the authority, my lord. That is what the Act says, my lord.
Okay.
We have already communicated. He will have a, my lord, right, my lord, he will get focus notice and he will contest it there, my lord. That is the forum, my lord. That is what the Act says.
Okay.
Okay.
Okay, we will reserve the order.
If I may, Lordship.
Yes.
The main point here is that I am a company. I am not the person to whom the seizure was made. I'm a company whose account has been freezed. I have come as a company exercising its right under Article 226. My fundamental rights has been violated. I am not that person in whose house they went to for seizure. This is the principal difference. This is the principal difference, my lord. And one more thing, lordship, I would just refer to a judgment with regard to the writ petition, lordship. Now, whatever the judgment that has been relied by my learned friend, lordship, these are with regard to section 8. Section 8 of the PMLA Act. Lordship, may kindly see what is section 8. Section 8 to dear.
No, not necessary. He
Yes.
has already pointed it.
Yes,
out.
lordship.
Section 8. Yes.
This is not with regard to section 17. My case is, lordship, is a very simple case. I am a company. My account has been frozen under section 17(1). I have approached the court, under 17(1). Kindly release my account because I have this problems. My fundamental right is violated, and this has happened. I have to run the company. I am a government contractor. I have been running government contracts. Kindly release. I am just asking for a relief against that section 17(1). Instead of replying to it, if they have filed it or not, if they have approached Delhi or not, there is no reply. This is mere submissions.
Okay. We will reserve the order. Heard Mr. Deka, learned counsel for the petitioner, and Mr. Dhor, learned counsel for the respondent. Order is at next item.
Item 27.
Highly obliged, lordship.
Regular bail application.
Yes, madam. And charge is also submitted.
Then my lord,
POCSO.
then is
Let
can
the
TCR
trial
may
court
be-
record come.
My lord,
Trial court record.
yes, yes. Trial court, sir.
Heard Mr.
M. Ali, ma'am.
M. Ali, learned counsel for the accused, and Mr. Sharma for the respondent. Mr. Sharma submits that in this matter service is completed upon respondent number 2, but no one entered appearance on behalf of the respondent number 2 today. Accordingly, this list the amicus curiae list.
This from Kamrup Metro.
Okay. It would be even regular one. M. Sharma. Okay. M. Mahorshi Sharma. Accordingly, Mr. Mahorshi Sharma is appointed as amicus to represent the respondent number 2. Mr. Sharma, learned counsel for the learned additional PP apprised this court that after completion of investigation, the IO has laid charge sheet before the learned trial court. Accordingly, it is provided that registry shall call for the record from the scanned copy of the record from the court of
Special Judge Kamrup Metro, madam.
Special Judge POCSO,
Kamrup.
Kamrup Metro. Kamrup Metro, fixing the matter on
Not yet sorted if possible, madam. It is from Metro.
Kamrup. Yes.
Charge sheet number
12.
Charge sheet number 65 of 26. Dated 29/5/26.
12 of August.
Unless.
Item 28.
Item 26 on POCSO matter, madam. Yes, my lord, may kindly produce the earlier order, my lord.
So here also we have to engage amicus.
My lord.
Or Miss, your name please?
A. Sharma, Lordship.
A. Sharma, learned counsel for the accused. Mr. Boisho for the respondent. Mr. Boisho, referring to the order dated 17/7/2026, has pointed it out that no one entered appearance on behalf of the respondent number 2 on that day. And today also, the respondent number 2 remain unrepresented. Accordingly, who can be engaged? Ranjan Borua to do it. Sagarika proposal to hire. Did you know? Srimati Monisha Karen Brown is appointed as amicus to represent the respondent number 2. Register shall reflect the name of Miss Monisha Karen Brown as amicus in to represent the case of the respondent number 2, and also reflect the name in the cause list and furnish the relevant papers to her well in advance and list the matter on short date. CD receipt here?
Yes. Can be said.
Okay. On? Well.
29.
My pleasure, Lordship. My lord, the case is registered under section 22C, my lord. Today is 82 days.
Today?
Today was called for.
Today 80,
82 days. my lord.
another 8 days are there.
Yes.
Heard Mr. Uddin, learned counsel for the accused.
One, my lord. State number is provided. So, my lord, communication, I don't have my lord, to submit my lord.
Hmm.
So, my lord, in the meantime, my lord, CD may be called for, or we will take instruction, my lord, written instruction. আমার communication হবে না।
Okay, then let the TCA be called for. Mr. Bhattakur learned additional PP apprised this court that they have received instruction that the IO has completed investigation and submitted charge sheet. In that view of the matter, Resisal called for the scan copy of the TCA from the learned trial court, fixing the matter on. No. 14 August.
May please, Lord. In this case, my lord, on the occasion of my lord, Eid lordship, Bakri lordship, someone, my lord, allegedly sacrificed cattle, lordship. My lord, considering my lord, one person was my lord released on bail, my lord, without calling for CD lordship. My lord, I was granted interim bail lordship. I have been released on bail, my lord. No misuse of liberty is there, lordship. Says my lord. Fixed for CD lordship. Already one person, my lord, 6 person altogether. 6 persons were there, lordship, arrested, lordship. One is
CD is not received.
19 lordship. That was considered without calling for CD lordship. At page 19 lordship.
My lord, items 31 also, my lord. What happened, my lord? From the same forwarding report, the honorable court, one of the co-accused released on the motion, my lord. And subsequently, we have filed a bill petition. My learned friend filed, and I have also filed another petition. And after 10 days of that release order, our bill was considered with the condition that the interim bill, my lord. Though regular bill, an interim order was passed, my lord. My lord, to honorable court may consider for the end of justice, because from the same forwarding report, already they are released on bail. Well, I think, my lord, the custodial interrogation may not be required. Yeah, my lord, already released, my lord. Interim bill was allowed, my lord.
Maybe we will see the case diary. Let the case diary come. Heard Mr. Ahmed, learned counsel for the petitioner, and Mr. Bhattakur, learned additional PP for the state respondent. Mr. Bhattakur submits that he has not received the case diary. Accordingly, it is provided that CD be produced before this court on certain. Till then, interim order pass earlier shall continue.
Lost.
I think 33 of the same.
Like that.
33.
30, 31 and 33.
30, 31, 33.
Same order is to be passed.
Same order.
Like that.
32.
Wait, please, your lordship.
Here is the service report every day. Taken the instruction that it is submitted.
Okay. Heard Mr. Sodhuri, learned counsel for the accused, and Mr. Locker, learned additional plea for the state respondent. Mr. Locker apprised this court that service report in respect of respondent number 2 has not yet been received. Place the matter on when? Tuesday?
6.
6. Resisal lays the matter on 6th of August. On that day, Mr. Locker shall produce the service report before this court. Whether CD was called for here?
Lordship, TCR is there, lordship.
TCR. Received.
Yes.
TCR.
Highly.
34. May I please, lordship?
Section 21B is involved. 55 days behind the bar.
Received. So,
12.6 grams, 12.6 grams, Lordship, when it is from this cause.
12.6 gram.
Lordship, from his position, Lordship. And the Lordship, the seizure witnesses implicated him, Lordship. He submitted on
It is pending trial.
Lordship for trial. He has submitted on 12 of this month, Lordship.
How many witnesses are cited in the search sheet?
8. It was started yet, Lordship.
Not started.
On 12 of this
No,
month.
whether search is framed.
On 12 this month, Lordship.
Search sheet submitted. 12. So, since search sheet is submitted, for how many days you are behind the bar?
55 days as on today.
55 days. Okay. We'll pass the order.
Publish.
36.
May it be pleases your lordship. Here, your lordship, as per the perusal of the last order dated, your lordship. Order dated 28/7/2026. The service report is awaited. And your lordship, notice was issued through the additional public prosecutor as per the notification dated 15/3/2024, which has been flag marked.
On 24 of this month, Lordship, steps will be taken next. Lordship, it will take some time, Lordship.
Your lordship, let the matter be listed after a week. Oh, mo pain to head.
Art Ms. Peters, learned legal aid counsel for the accused, and Mr. Crawford, learned additional PP for the state respondent. Office note dated 23rd. No, 28/7/2026 indicates that service report is still awaited. And that the notice was issued through the additional public prosecutor. As per notification dated 15/3/2024. In that view of the matter, Mr. Locker, learned additional PP is directed to obtain the service report from the officer in charge jurisdictional PS and rest is list the matter on 1 week.
On 10th of August.
10.
I'm
That will
deeply
be
obliged.
too long, huh? Sorry. 6 of August.
I'm deeply pleased.
37.
CS submitted.
On the last occasion, my lordship wanted to peruse the injury report, my lord. Because my lord, as per the discharge certificate, my lord, there is no such grievous injury.
It will be called for. CS submitted, it will be called for.
What is the maximum period of punishment prescribed for the offense?
10 years.
10 years.
10 years.
Uh,
59 days. behind.
Where the TCR will
CS
come?
submitted, Lordship.
From where the TCR will come? Sonetpur. Tezpur. Okay, we'll fix a short date. Heard Mr. I.S. Soikia, learned counsel for the accused. Mr. Lockwood, learned additional PP for the state respondent. Case diary has not been received. Mr. Lockwood apprised this court that after completion of investigation, the IO has submitted search sheet being search sheet number
62/26. It is 28/7/26.
Okay. In that view of the matter, SSL call for the record of the learned trial court fixing the matter on 6 of August. 6 of August.
39.
CD player not received, Lordship. It's an interim, Lordship. It's not.
You are on interim.
Yes, yes, my lord.
Heard Mr. F.K.R. Ahmed, learned counsel for the petitioner. for the applicant, and also heard Mr. Locker, learned additional PP for the state respondent. Mr. Locker appraised this court that he has not received the case diary. Accordingly, it is provided that Mr. Locker shall produce the case diary before this court on
Lordship, he has indeed not after
18. Till then, interim order dated 24/3/2026 shall continue.
All right.
May it please your lordship, this is a pre-year's bail. On the previous date, the CD was called for.
Here also we have not received the CD notice.
The petitioner is not a criminal. Actually, his name was been taken by the person who has been arrested. So in the last few dates also, the CD has not been arrived.
Mr. Your name, please?
M. Islam on behalf of
Learned counsel appearing on behalf of
MS Sodial.
MS Sodial, learned counsel for the applicant. And also heard Mr. Locker, learned additional PP. For the state respondent, Mr. Locker submits that he has not received the case diary. But it appears that case diary is being awaited since 29/4/2026. And on last 4 dates,
Yes.
the learned additional PP has failed to produce the case diary before this court. Recess will list the matter on sorted.
5th of August or 6th, 7th of August.
5th of August. And in the event of failing to produce the case diary before this court will proceed to hear and dispose of this application without producing the case diary.
Obliged.
41.
May I please your lordship? Lordship, contracting counsel could not appear today. Lordship, kindly fix it on Monday, lordship. He just left the court for some urgent work, lordship.
Heard Mr.
Yehuda,
learned counsel appearing on behalf of
appearing on behalf of petitioner.
No, who is the conducting counsel?
NJ Dutta.
NJ Dutta. And submits that Mr. Dotto has some inconvenience today, and as such, the matter may be listed on some other day. Pair allowed, list the matter on sorted.
Lordship, kindly fix on Monday, lordship, if possible.
Next Monday,
Yes, on 3 of August.
3rd of August. Okay. Okay, we'll try Monday. Mr. RK Devsodri, learned. Special PP,
No, deputy chief.
deputy SDA. Oh, NCB, present.
Obliged, lordship.
Lordship, this is the POCSO method and services still awaited. Filed office note dated 28/7.
Heard Mr.
R. Mali on behalf of S.
Learned counsel appearing on behalf of Mr. S. Novas, learned counsel for the applicant, and Mr. B. Sharma, learned additional PP for the state respondent. Office note dated 28/7/2026 indicates that service report is still awaited. It is POCSO matter. Accordingly, it is provided that Mr. Sharma, learned additional PP, shall obtain the service report from the officer in charge jurisdictional PS and place the same before this court on Tuesday. Okay.
4th.
Item 44.
Obliged, lordship.
May it please your lordship. Pre-arrest bail was, interim order was passed in my favor. Accordingly, I appeared before the police station and recorded my statement. 44.
Here, charges submitted, my lord.
Against whom?
There are two accused.
My lord.
Yes. Against both of them, search sheet submitted.
The promotion is not here, my lord, charge sheet
But
number.
actually, what happened, I have rent out this hotel to one Deepak Burman, who was arrested and enlarged on bail. Section 3 and 4 is there, my lord, in this
And
case.
section 6 also edit, my lord. Section 6 also edit, my lord.
You are appealing for?
I am for the original owner of the hotel, my lord. I have rented out to Deepak.
It before the learned trial court, but he is not sure as to whether search sheet is submitted as an against the present applicant or not. In that view of the matter, it is provided that Mr. Sharma shall obtain necessary instruction as to against whom the search sheet was submitted. Recess shall raise the matter on Monday.
My lord.
Monday.
My lord.
45.
My lord, here he did receive, my lord, but has it reported everything?
It's POXO matter.
POXO matter.
So when the notice was sent to the respondent number 2,
My lord, we have taken step on 22.
22 of
Yes,
this month,
Yes, this month, 22 July.
to the office of the PP.
It went on 28 maybe.
My lord, from 28% from our office, my lord.
From on 28. Okay, next week then.
After, my lord, after 1 week.
Third Miss,
MS Dida's lordship.
learned counsel for the applicant, and Mr. B. Sharma, learned additional PP for the state respondent. Office note dated 28/7/2026 indicates that service report is still awaited. Let's list the matter on. Okay. Sorted next week. 7th of August. 7th of August.
Highly obliged, lordship.
22.
May I please, Your Lordship, where in this case, Lordship, the appellant convicted under section 4 of POXO Act, Lordship, for 10 years. Lordship. So, Lordship, at this stage, Lordship, notice may be issued, Lordship. And here may be called for, Lordship.
Heard, Mr.
I.U. Chaudhary, Lordship.
Learned counsel for the appellant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This appeal under section 415(2) of the BNSS 2023 is directed against the judgment dated 19/6/2026 and the order dated 23rd/6/2026 passed by the learned Special Judge POXO Kukrajar in special case number 156 of 2023. It is to be noted here that by the interim judgment and order dated so and so, the learned Special Judge POXO Kukrajar hereinafter trial court has convicted the appellant under section 4 of the POXO Act and sentenced POXO Act read with section 448 of the IPC and sentence him to suffer rigorous imprisonment for 10 years and also to pay a fine of rupees 25,000 with default stipulation and also sentenced to rigorous imprisonment for 1 year and pay a fine of rupees 1,000 with a default stipulation under section 448 IPC. The sentence order is at page number here. Is it 14?
Page, Lordship, page 14, Lordship.
1-4.
Lordship, 1-4. Relevant page, Lordship, 16.
Admit. Issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Call for the record from the learned trial court. Step upon respondent number to be taken through the office of the PP. In appeal also, notice has to go through your office. Okay. Within a period of 1 week from today. List the matter after 4 weeks.
Any date, Lordship, after 4 weeks?
IA is there.
IA is there, Lordship.
Issue notice. In IA.
After 4 weeks.
Any
After
date?
4 weeks.
No, within that.
7 September.
Deeply aware.
May I please, your lordships? This petition led to interim custody of my motorcycle, my lord. My only motorcycle, the dropping and lifting my child lordship from the school. And records received lordships. Received. Records received, scan copy received lordships.
Here in the policy, it was not shown, my lord. But yes, going through it, my lord.
You go through the same, we will list the matter tomorrow.
Lordships, no, received lordships.
No, receive, but in the
We
policy, it
have
was
to
not
go
shown.
through the record.
But my lord,
Additional PP has to go through the record.
interim custody, tomorrow lordships.
No, finally we will dispose of the matter. Why should we pass interim order?
In the policy, it was not shown. That's why we are not verified in the report, my lord.
I verified it is there available.
You could have informed him in the morning then.
Oh,
Heard Mr.
That's
Borumia
not
learned
easy.
counsel
Come on,
for
but we have knowledge.
the petitioner and Mr. B. Sharma learned additional PP for the state respondent. Office note. Dated 27/7/2026 indicates that scanned copy of the TCR has been received. However, Mr. Sharma submits that as the said fact has not been reflected in the cause list, he could not go through the record. And accordingly, it is provided that SSL list the matter tomorrow.
Obliged.
For hearing, item 47.
Kita আছে?
May please tell us. Receive
Yes.
this. Meet the participant. Maintenance under section 125 CRPC. The petitioner file application under section 125 CRPC claiming maintenance from her husband. That is, application is at page 9 Annexure 1. Page 9
So,
is
the petition was allowed or dismissed?
dismissed, Lordship.
Dismissed.
Rejected.
Why?
Mainly on two grounds, Lordship. And she, let's see, she went away from her husband.
This petition is pending since the year 2014. And during the pendency of this petition, Honorable Supreme Court has pronounced the decision in the case of Rajneesh versus Neha. To find out the citation from that. Wherein Honorable Supreme Court has stated that the Supreme Court has stated that in a proceeding under section 125 CRPC, the parties have to file their affidavit indicating their assets and liabilities. After hearing learned counsel for both the parties, this court is of the view that in order to adjudicate this revision petition effectively, the parties may be directed to file their affidavit indicating their assets and liabilities. Accordingly, both the parties are directed to file their affidavit indicating the assets and liabilities on or before 24th of August.
That's it.
24th of August. The learned legal aid counsel, Ms. Devi, shall contract the petitioner hearing through the High Court Legal Service Committee and also the District Legal Service Authority of Dorong District, Mangalore. This is the matter on 24th of August. 25th then.
Obliged.
48.
I declare on behalf of RB Bora for respondent number 2.
RB?
RB Bora. In spite of orders 26 and 14 that 26 located, they have not contested from the state of Chhattisgarh and Gauhati.
None appears for the appellant on call. How about Miss
S. Bora on behalf of RB Bora.
S. Borua? Bodo, learned counsel. On behalf of Miss R.B. Bora, learned legal aid counsel, for the respondent number 2 present. Mr. Sharma. Are you not a party here?
The party is not part of it. We are formal party.
Formal party. But you see, maintenance. Against that order, they have preferred on revision. before the district judge, session judge. And against the order passed in the revision, they have preferred the appeal. Is it maintainable? Hmm? Maintenance was granted or not granted? You do not know.
Memo of appeal was perhaps not given to the.
Not given, okay. Okay, problem is that the appellant is absent.
Order dated lordship 14/5. At 18/6. The petitioner declared not directed to go.
No, the question is whether against the revision, this appeal will lie. None appears for the appellant on call. However, Ms. So-and-so, learned counsel for the respondent. Present. Colony agora. Recessal is the matter Monday. No, this is not admitted, in fact. For hearing on the point of maintainability. Tuesday. Okay, Tuesday.